matter may be closed.
MSc was overall and council for the subjects. The matter has become in practice. Accordingly, this is disposed of as
Must have been.
Yeah, please, your lordship. Lordship, with the consent of the other side, I beg to mention item number 6.
Yeah,
Finally, the matter may be taken up after 1 week.
you have four?
I am for the petitioner.
I have a respondent. Okay. You have good time?
PJ Bora.
On request made by BG Boral and the council for petitioner, list of the rules. Yeah.
I'm praying for listing of that, the MBBS admission matter, my lord, that was directed by your lordship to be listed today.
Oh,
Unfortunately, it's not in the list.
this is not coming.
Spoken to Mr. Gogoi, my lord, can be listed for Monday, 31st. month. It be taken up on Monday.
Monday?
Monday.
Okay.
Lovely.
May I please, your lordship? Lordship, I beg to mention for listing up a contempt matter for orders. The matter may come up on any date,
16th.
16th, take your place.
May I please your lordship? Lordship, I beg to mention for listing of one writ petition on Tuesday, my lord,
Why,
for admissions.
why Tuesday?
Lordship, the petitioner, his studentship has been suspended for next 1 year. So there was an interim prayer also.
We'll have it on. We'll have it on.
Third, obliged.
May it please your lordship, I beg to mention for listing up to WPCs of similar nature for admission. Any date as per your lordship convenient.
17th.
Bless.
Me, please, your lordship. Lord, I may be allowed to move an urgent writ petition tomorrow.
Why?
My lord, the urgency is that, my lord, this is a matter pertaining to.
Have you filed it?
Yes, my lord, already filed it. Recruitment pertaining to post of principal, as per the NCT guidelines, my lord, 2014, the requirement essential qualification is PhD as well as, my lord, MA with 55% mark. My lord, the respondents, they are contemplating to promote, appoint persons who don't have this essential eligibility qualification, my lord. They are contemplating, my lord. At any moment, they can pass the order. That's why, my lord, kindly.
No, how do you know that they are contemplating?
No, they have already convened the DPC, my lord. They have already convened the DPC and they are contemplating, my lord. That is how, my lord. And in the DPC, they have include persons who are who don't have this eligibility qualification, my lord.
Okay.
Highly obliged.
Item 1 of daily list.
The direction was there to produce the minutes dated 5/10/2021, Lord.
What's the name of the petitioner?
Yes, I flag it out, Lord. Serial number 37.
Yes.
Only 24 days left. So our High Court is considering it.
You have further tight on?
Item 10/8/2002.
When did you make your application? When did you make your application?
According to record lordship 1/1/2017 applicant.
Then-
Almost after 15 years.
After 15 years, you make your application.
Question is not that lordship. Due to my age lordship, it is.
So you wanted to become a major, then after you get your qualification, you apply. It is an alternative source of recruitment without following the due procedure of law. That's all. It's not a question of compassionate appointment.
They consider lordship.
Now it is
No, we can't.
2023.
DLC consider
Now
lordship.
it is 2023. Father died in 2002. So
DLC not considering the
very most
submission
of the
time. lordship.
compassionate
That's why I,
appointment is to
before this court.
meet up the immediate financial hardship.
DLC is already considered lordship.
Hmm.
And each and every case lordship, after 2017, it is already closed. Each and every case is already for 6 years lordship. After 2017 lordship, there is no any compensation accommodation. I am not so late lordship.
Not late. 15 years is not late.
Is it?
15 years is not late.
Kindly consider lordship, it is not a fake
No.
lordship. Fact is that lordship, I am not attained the
But Chalamgir learner concept for the petition.
similar matter is also considered lordship.
I'm appearing for 1, 2 and
Also heard Mr. F. Sukat,
respondents 1, 2 and
then Standing Council, Elementary Education Department, for respondents 1, 2,
4.
I am
and
for
4.
respond number 3.
And Mr. Sabora, Leonard Barol, Leonard Standing Governor Advocate for respond number 3. Stop. The father of the petitioner, while serving as a head teacher at 97 number Dinanathpur LP School of Hailaganda district,
Lordship, kindly, in Supreme Court judgment, lordship, one is considered also 5 years old.
5 years, this is
Yes.
15 years,
No, in that time, he is 5
Right.
years.
died in harness on 10/8/2022. During the demise of the petitioner's father, petitioner was a minor. Stop. Thereafter, the petitioner met her application for appointment on compassionate grounds on
01/01/2007.
1/1/2017. At the time of the application, the petitioner was 17 years, 11 months and 6 days. The district level committee, Hailakandi, in its meeting held on 5/10/2021, considered the case of the petitioner and rejected her case on the ground that at the time of submission, her age was 17 years, 11 months and 6 days. And the deceased employee died on 10/8/2002. And the application was submitted on 1/1/2007. The scheme of compassionate appointment is meant to take immediate care of the hardship of the deceased family. And in the present case, the petitioner has met her application after a lapse of 15 years. And that too, when she was only 17 years, 11 months, 6 days. So, in that view of the matter, this court is unable to consider, there's no merit in the pending petition. And the petition is accordingly dismissed.
To admission.
Yes.
My lord, this matter relates to provincialization of service, my lord. The petitioner before lordship was appointed as principal of South Salmara College pursuant to resolution dated 6/8/1988. And he was appointed on the same day And after his appointment, my lord, the college obtained all the necessary formalities from the government, my lord. I have given the list of dates, my lord. So last occasion also, my lord, was given, perhaps it is not in the record.
What is it?
The list of date, my lord. On the last occasion also I gave, but
Okay.
it may not be on the record, my lord. I don't know, my lord.
Anyway,
My lord. So, my lord, at the time of his appointment, when he was appointed, the qualification prescribed was, my lord, not 55%, but it was 50%, my lord, at the, my lord, PG level. And he was, he was a, my lord, postgraduate in economics, my lord, and he had 50.25%. 50.25%. So, my lord, at the time of his appointment, he was qualified. And therefore, my lord, his service should have been provincialized along with the other staff of the college. But the respondent authority, my lord, holding him to be underqualified, did not provincialize his service, but the services of the other officers, my lord, and the non-teaching staff of the college were provincialized way back in the year 2013 itself, under the 2011 Act. Now, petitioner is, my lord, claiming provincialization with retrospective effect, as the other staff of the college was provincialized, and because of the, my lord, error made by the respondents, his service was not provincialized. Though the post was sanctioned, post is sanctioned in principal, post of principal is sanctioned post, my lord, in the college. My lord, in the meanwhile, my lord, he also retired from his service on attaining the age of superannuation on 31/10/2020. He retired from service. So, my lord, if he gets the benefit of provincialization, my lord, till his retirement, that will suffice his purpose, my lord. Now, the respondents have filed an affidavit where they have stated that the prescribed percentage was 55%.
where is that? Respondent number?
Respondent number 2, my lord. The director, my lord. Director of Higher Education has filed the affidavit. My lord. In paragraph 8, page 4 of the affidavit, my lord.
Yes.
Well, in paragraph 8, they stated that the requirement was 55% in master degree or equivalent, as per the, my lord, notification dated 17/6/1987. But, my lord, the said notification was subsequently amended prior to appointment of the petitioner, whereby this criteria of clause 10 of the notification was deleted.
Where is that amendment?
That amendment, my lord, this compilation I made on the last occasion, I also supplied this compilation, because I have, my lord, inquired that the compilation is not in the record. So, can it be taken about 2 p.m., my lord? I'll make a copy, my lord. But
Not
there
too
this
bad, we'll
compilation,
take it up some other day then.
2 p.m. is,
But I had seconded it also for the petition. Also had Mr. K. Gogol and it's second also for the higher education. Place the matter again on. We'll give you 1 week time.
at 2 p.m. also I can do, my lord, because only thing was the compilation I have to xerox, my lord. Other things are here.
Yeah, Gogoi, you want at 2?
Maybe I may be in other court.
Chamoy.
Next Tuesday, my lord. If possible, my lord.
We'll have it on 3rd.
30.
My-
No,
3rd of August.
3rd of August.
My lord.
Final record of
Oblige, my lord.
Mr. H. Amal, then it's standing council.
UGC for respondent 5.
UGC appears for respond number 5.
Oblige, my lord.
Three.
Well, this matter relates to provincialization of service, my lord. Petitioner school was provincialized along with the service of all teaching and non-teaching staff, my lord. Respondent number 5 hearing, my lord. He and the present petitioner, both are Hindi teacher, my lord. But survey and respondent number 5 is junior to the present petitioner, my lord. But his service was regularized, my lord, provincialized, but and petitioner is deprived of her right, my lord. And after receiving the notice, my lord, a respondent director conducted a hearing, my lord, calling the inspector of schools and petitioner and the respondents. After hearing, my lord, come to a conclusion, and to that effect, they have filed their affidavit, my lord. Lordship will find in their affidavit, paragraph 7, page 44, my lord, running page, my lord.
Yes.
May I read, my lord, that in the hearing, it is found that Jitumoni Kumal, the petitioner, is senior to respondent number 5 as the date of joining of petitioner. Jitumoni Kumal was 18/11/2003 and the date of joining of respondent number 5 was 17/11/2004. Subsequently, the respondent director had office order dated so-and-so 28/4/2022 asked the inspector of schools not to give effect of the provincialization of respondent number 5 until further order of the instant writ petition. So, my lord, order, my lord, is not given effect to so far as the respondent number 5 is concerned. So, my lord, in the last date, my lord, Lordship wanted to know whether copy this notice was served upon the respondent number 5 or not. And Lordship was pleased to found, my lord, that the notice was duly served, my lord. Even then, he did not appear. And Lordship, in the last order, give a last chance. Was pleased to give a last chance, my lord, so that he can appear. And Lordship may dispose it of because respondent number has already filed their response, my lord, admitting my claim. Service of other teachers already they are getting their regular salary, my lord. School is provincialized, but due to this pendency of this case, my lord, the petitioner service is not provincialized.
Yes.
Well, in this regard, we have filed the affidavit, and in the affidavit, we have stated that the Jitumoni Komal is senior to the respondent number 5. Your Lordship.
That is that hearing you have done.
Yes.
Only part is respondent 5 is not present.
Yes, my lord. One chance may be given to the.
No, my lord,
respondent number 5.
notice are, my lord, already long back, my lord.
No, there are two issues. If respondent number 5 is there, we can pass an order. If he's not there, we'll have to direct you to the tribunal.
My lord, he received the notice and he decided not to contest, my lord. So,
So in
perhaps, my lord,
let the tribunal take a decision.
my lord, again, my lord, this is the admitted case, my lord.
No, it may be an admitted case. It is only an admitted case of the director only.
My lord.
Let us see what the respondent number 5 says.
I have submitted in
Was
the,
respondent number 5 heard when the director heard the
yes, respondent number 5 was present in the, my lord, hearing. But present petitioner, SC, my lord, was
how
ill.
do you know that he was present in the
My lord, in the affidavit, they have mentioned, my lord. Lordship will see the paragraph 6, my lord. Paragraph 6, last, my lord. The petitioner, in the bottom, my lord, the petitioner claims that she is the junior, so and so. In this respect, deponent states that a hearing was conducted on 3/12/2021, wherein the inspector of schools, LDC, Lakhimpur, headmistress of Jugisuti tribal, so and so, Nirmal Vishwakarma, this respondent number 5, and Jitumoni Kumal were called. But petitioner Jitumoni was absent in the hearing. Petitioner could not be present, my lord, but headmistress as well as the respondent were present, my lord.
Yes, you Sharma.
My lord, maybe remand back to the tribunal so that their response maybe come out in the tribunal.
Well, in that case, my lordship will give, I'll submit, my lord, let's give him one more chance, but my lord, again remanding back to the tribunal, again, my lord, initiation, another process, my lord.
Your good name, please. Kalita.
Yes, my lord.
Heard NK Kalita, Learning Council. Also heard Mr. U Sharma, Learning Studying Council, Secretary Education Department. None appears for the respondent. In the interest of justice, this the matter after 2 weeks.
After 2 weeks,
Lordship will make an observation that on that, my lord, final order will be
That
disposal.
observation I've already made in the last order.
Yes, my lord, that is why, my lord, I praise, my lord.
If the respondent number 5 is not represented on the next agreement date, this case shall be finally taken up for final discussion.
Or
Due to some personal difficulty, my lord, I'm also not ready with the records of the Guwahati University. My lord, the make up on next Thursday, my lord. On 3rd of August, my lord.
3rd of August, my lord.
Mr.
T. Chakraborty, my lord.
But Mr.
T. Chakraborty.
T. Chakraborty. On request met by Mr. P.G. Fukan and Standing Council, Guwahati University.
University.
Thursday, 3rd is, I've got a lot of cases. 8 August.
No,
Most of them. Tuesday.
by
Oh,
Wait, please, lordships. My lord, matter basically, my lord, pertains to my lord, non-provincialization of service, my lord. Here, my lord, petitioner was appointed in the year 1988, my lord, as an assistant teacher, my lord. My lord, although, my lord, as per 2017 Act, my lord, their school was supposed to be provincialized, my lord, but that was not provincialized, my lord. Even then, my lord,
school is not provincial.
no, my lord.
Yeah.
Now, my lord, the headmaster has already been retired in the year 2021, my lord. Even after retirement, my lord, the headmaster is also not handing over the charge of the school, my lord, to the petitioner, my lord. Now, my lord, the petitioner in a peculiar situation, my lord, neither he is running well with the school, my lord. Now, my lord, last August, my lord, the respondents were directed to file their affidavit, my lord, but they have not approved, my lord, come up with this affidavit, my lord.
So for my recent instruction, my lord, I am for respondent number 6, my lord, headmaster, my lord, retired headmaster. So far, my recent instruction is concerned, my lord, he has handed over all the, my lord, record, my lord. Date is not mentioned because he is suffering from some ailments, my lord. Before my lord retirement, also my lord, till date, my lord.
Have you filed your affidavit?
No, my lord. That's why I'm praying for my lord for 5 days time, my lord, or 7 days time, my lord. I will file affidavit.
And how about the other respondents?
if I was waiting for the elementary education. I
Are you-
received certain instructions, Your Lordship, I would like to bring it on record.
What is it?
I have received certain instructions, Lordship, regarding the matter, Your Lordship, I would like to file an affidavit. I would like to place it on record. Regarding the working of the school
But
and everything.
Mr.
Yes, Hawk, my lord.
S. Haklan, counsel for this.
Yes.
Mr. F. Fukan, standing counsel, Elementary Education Department. As well as
Yes.
Mr.
S. Ahmed for response number 6.
Leonard counsel for response number 6. Are both allowed. How much time you want, Fukan?
Your Lordship, 2 weeks.
Without 2 weeks time to file the respective form.
My,
Obligement.
my lord, matter will be
Achha.
fixed after 2 weeks, my lord. Kindly, my lord.
After 2 weeks.
Any date, my lord.
No date.
Obliged.
7.
This matter, my lord, the pleadings are otherwise complete. The matter is required to be taken up for disposal. I leave it to you, Lord.
Otherwise, Lordship, it's a premature matter. As per Lordships also observed that the decision was not attained finality, Lordship. Here I am the instructions from the college authority, Lordship. They have not, even that was not reached to the directorate also. That I found also.
What matter is this?
This pertains to selection of lecturer. The issue is, in a nutshell, issue is like this, madam. Issue is like this. If my challenge is, there is a difference of less than 1 mark. I am questioning 1 mark that has been awarded to the private respondent, whether it is permissible or not. If it is decided in my favor, she will be out. And if it goes against me, the selection remains. There's an interim order protecting me. So if your lordship wants to hear, I can proceed. They are taking up the plea that it is yet to be approved by the director.
It's up to you. If you are ready, we can hear it. Otherwise,
Lordship,
It will require
my
some amount
submission
of.
is that, Lordship. It's a premature matter unless and until it was attained finality. It was taken decision by the directorate, Lordship. It's a premature matter. Our High Court judgment is there, Lordship. And it was reported judgment 2017 1 GLP 77. When my lord also decided so many cases regarding premature. Let petitioner may submit the representation before a directorate by ventilating her grievance, Lordship.
who is supposed to approve the selection?
The director also.
According to this instruction now, I don't know.
College has not taken final decision till today, Lordship. After taking the decision, Lordship, they have sent it to the directorate, Lordship. After that, Lordship,
I am questioning the very decision-making process adopted by the selection committee itself. I am saying that the decision-making process adopted by the selection committee in awarding the mark itself is not permissible. So therefore, my lord, perhaps this argument that this is premature will not even come. Because what is being tested before your lordship is the decision-making process of the selection committee.
Okay. Yes, Gopal, you're ready to
No,
or you?
no, regarding hearing, I have no problem. But as per the law laid down by our
No,
court,
let us hear,
Yeah.
let us hear after that, we'll take come to this.
Lordship, we have no
Uh,
problem. That issue we have
You
no
are
problem.
agree?
Yes, Madam, I am appearing from the private respondent number 6, and this issue of 1 mark was already gone into by this honorable court. And it was already settled, my lord.
That also I'll answer, man.
What is it?
My lord, there is a judgment of this honorable court where in another petition, the same issue was raised, my lord, that I am not entitled that 1 mark teaching experience. And this honorable court has been pleased to hold that no, I am entitled, my lord, and I have annexed that order in my IA, my lord. So I think that issue is covered by your lordship judgment, madam.
I will address your lordship on that also. That my lord, judgment, the OM that we are placing reliance on was not even brought to the notice of this honorable court. So therefore, it is a judgment, express a judgment power in Korean.
Here, the very sheet anchors, the very basis on which I have challenged, that basis is non-existent in the judgment.
You are appealing for respondents?
Respondent number 6, private respondent number 6.
Okay.
He is the person selected.
It's up to you. If you are ready, we'll take.
I am-
Otherwise, we can fix another date. It's up to you.
I am ready, my lord, subject to your lordship's convenience.
If pleadings are complete, we can also issue, or you want it in the admission stage.
Let it be in the admission stage, because they have some urgency. There is an interim protection in my favor. Your lordship can, if your lordship is desirous of taking it up today, I am ready. my lord. Otherwise, your lordship can fix a date
Because
for
of the,
for disposal at the admission stage.
because of the interim order, now process has been halted midway, my lord. So, but there's some urgency.
Some urgencies, sir. Then we can proceed.
But the facts are like this, my lord. This pertains to selection for the post of assistant professor Sanskrit, my lord, in Nalbari College. There was an earlier round of litigation. Your lordship will find the judgment at page 48.
Yes.
If your lordship kindly turns to page 51, the operative portion. Para 10.
Why did you approach this court?
I hadn't, my lord.
Oh,
It was the respondent number 6 who had approached, saying that midway the rules of the game were changed, and that is what was under challenge, and that is reflected in para 10 of the judgment at page 51. May I read it, ma'am? In the view of this court, the ratio laid down by the Supreme Court in Madan Mohan Sharma would be squarely applicable in the facts of this case, also in as much as on the date on which the advertisement was issued on 4/7/2015, the office memorandum dated 25/6/2012 was enforced, whereas on the date when the interview was held on 4/10/2015, the subsequent office memorandum dated 14/8/2015 had in the meantime come into force. Accordingly, this court is of the considered view that the selection process pursuant to the advertisement dated 4/7/2015 would be covered by the procedure prescribed in the office memorandum dated 25/6/2012 and not the subsequent office memorandum dated 14/8/2015, as the office memorandum of 25/6/2012 did not provide for holding any interview. Therefore, the act of the respondent college authorities in holding an interview on 14/10/2015 and awarding 20 marks for the purpose would be without jurisdiction and derogates the provision of the office memorandum of 25/6/2012. Mr. So-and-so learned counsel appearing for the respondent college authorities makes a submission that the petitioner came to know about the interview on the day she received the call letter, and having participated in the interview and on being successful, now the petitioner cannot turn around, etc. But this preliminary objection was taken. Thereafter, my lord, the submissions are recorded, and the operative portion your lordship will find at page 53, para 16. In view of the above, this court is of the view that the procedure adopted by the respondent authorities in following the office memorandum of 14/8/2015 for holding the selection process pursuant to the advertisement dated 4/7/2015 would be vitiated, inasmuch as on the date of the advertisement, that is 4/7/2015, the earlier office memorandum dated 25/6/2012 was enforced. Further, it has also to be taken note of that as per the affidavit filed by the Director of Higher Education, the vacancies that were advertised in the advertisement of 4/7/2015 were given the permission to be advertised on 25/6/2015. Therefore, at least on the said date, the vacancies had already arisen. In view of the above, the interview as well as the selection process held on 4/10/2015 is accordingly interfered and set aside. The respondent authorities may now proceed with the selection process pursuant to the advertisement of 4/7/2015 as per law. Now, my lord, basically it was remanded back. Now, what had happened was this, my lord. There was 1 mark awarded to the respondent number 6. On the basis of this certificate, your lordship will come to page 27 of the writ petition. First 26 one. This was a certificate that was originally submitted by the respondent number 6. Page 26.
Yes.
So what it says, I'll take your lordship to that guidelines. What is required to be done is 1 mark per year of experience. Now, your lordship will kindly have a look at this certificate. Firstly, your lordship will make a note of the date, 13/8/2011, and this is the content of the certificate. This is to certify that Miss Chandana Deka, MA MPhil, so and so, served as an ad hoc lecturer in the Department of Sanskrit in MNC Balika Vidyalaya, Mahavidyalaya, etc., Nalbari, during 2009-2010. And she has been serving as part-time lecturer for the session 2010-11 and 11-12. Both are purely temporary and terminable basis, etc. It does not mention during 2009-2010, what is the exact period? If it is anything less than 1 year, she will not be entitled. Now, disputes arose with regard to this certificate. What she does is this, if your lordship kindly turns to page 27, now she gets this second certificate. This is to certify that Miss Chandana Deka, etc., has served as a teacher in Sanskrit in an ad hoc capacity during the session 2009-10 for 1 year. Now this 1 year is mentioned, which was earlier not mentioned. The interesting thing comes now. If your lordship kindly turns to page 33, this certificate at page 27 is on the basis of this application is at page 33. If your lordship holds both the pages together, if your lordship will kindly first come back to page 27 for a moment, and your lordship will kindly note the date, 10/2/2015. And now, your lordship will first have a look at the contents, and I'll come to the contents later, madam. Received 17/3/2015. This application was received on 17/3/2015, and she gets the certificate on 10/2/2015. 1 month and 7 days prior to she having even applied, she gets this certificate at page 27. And your lordship will kindly have a look at the contents. With due respect, I inform you that I served as an ad hoc lecturer in the Department of Sanskrit in your college during 2009-2010 and have been serving as part-time lecturer for the session 2010-11 and 11-12. Both are purely temporary and terminable basis. She says that she has served during, exactly like page 26, what has been said originally in the certificate, during 2009-2010. But now your lordship will look at the prayer in that application. Now I am in need of a certificate of an ad hoc lecturer during 2009-10, mentioning 1 year service, for which act of kindness I shall be grateful to you. Even while she is stating the facts, she says that she served during 2009-2010, but she is asking for a certificate mentioning that I have served for 1 year. And this is exactly what is given. She submits it on 17th of March. On 10th of February itself, the certificate is issued. So this is the factual doubt that arises out of these documents. And even otherwise, if we accept these documents on their face value, what is the implication? The implication is this, madam. First, your lordship will kindly turn to the concerned OM 25/6/2012, which your lordship will find at page 54.
This is dated
25th of June 2012. This is the OM which was required to be followed. The date is clearly mentioned at page 56. If your lordship kindly turns to page 56, your lordship will find in the chart towards the middle of the page, your lordship will find teaching experience 5 marks. And how it is to be given, awarded is teaching experience, 1 mark for each completed year of service in an affiliated government degree college subject to maximum 5 marks. Since it says completed year, so the first certificate becomes meaningless. She applies for a second certificate. Even there, she says that I have served during 2009, 2010, but give me a certificate mentioning 1 year. And that is what is given. Now, how is this to be understood? Is if your lordship kindly turns to page 30. It is mentioned that she has served on ad hoc basis, part-time, etc., etc. That whole thing is unbelievable because of this OM. Your lordship will kindly have a look at the contents of this OM. Subject is prohibition of engagement of teaching and non-teaching staff in deficit grants in aid college without sanctioned posts. So whatever name you give it, you call it a ad hoc employment, you call it a part-time employment, whatever you want to call it, there has to be first a sanctioned post in existence. That is the mandate. In continuation of this department's GM so-and-so dated 17/7/2004, the following procedures, formalities are prescribed for banning the appointments of teaching, non-teaching staff against non-existent posts in deficit grants in aid colleges. Henceforth, no college under the deficit grants in aid system shall engage any person for a teaching or non-teaching work where no sanctioned post exists for the purpose of filling up of vacant sanctioned posts. Existing government instruction guidelines will be responsible for any violation of the above sanctioned conditions. All members of the governing body or the college, including the principal, secretary of the college, will be responsible for any violation of the above mentioned conditions. The member secretaries of the respective colleges shall invariably submit reports of compliance to the above conditions twice in a year, and second report as on 1st April of the year and the second report as on 1st October of the year as a precondition for release of one to such college by the state government. There is a blanket ban on engagement of any teacher against non-sanctioned posts. If the post is not in existence, you cannot. Now, factually, the fact that she could not have served in this post has come out from their own materials, madam. If your lordship, we had made a statement that there was no sanctioned post at para 5 of the writ petition. If your lordship will kindly come to para 5, page 9.
Yes.
Towards the middle of the para 5, right hand side, line about, my lord, 8 from top, there is a sentence starting in this context, as my lord got it. In this context, it is worth mentioning that there is no sanctioned post of Sanskrit in Mahendra Narayan Chaudhary Balika Mahavidyalaya, Nalbari. And therefore, the question of appointing the respondent number 6 as ad hoc lecturer in the Department of Sanskrit does not arise. This is a categorical assertion we had made. At that time, we did not have the relevant materials. Now we have managed to lay our hands on RTI replies. If your lordship will kindly take up our affidavit in reply. It will be running page 74, madam. The affidavit should start at page 61.
Additional affidavit.
This is an affidavit in reply on behalf of the petitioner against the affidavit in opposition filed by the respondent numbers 3, 4, and 5. It should be running page in the paper book. It should be running page 61.
Yes.
And in that, if your lordship will kindly come to the last page of that affidavit, page 74. we had submitted an application seeking information, and this is the reply that the college has given, from which the respondent number 6 had obtained the certificate.
Which?
Page 74. I have the honor to state that there are no sanctioned posts of assistant professor in the Department of Sanskrit till date in MNC Balika Mahavidyalaya, Nalbari.
This is in that affidavit in opposition, reply to affidavit in opposition of 7 and 8.
Your lordship is right. Right. So the college itself is saying that there is no sanction post, even till date. This is dated 23/5/22. So it does not matter whether she had rendered any ad hoc service, part-time service. There was no sanction post, and the government had expressly banned engagement of anyone. So against this, assuming she had actually done one completed year, she had experienced, it becomes meaningless, because that cannot be counted for the purpose of this teaching experience. Now, the argument that has been sought to be advanced on behalf of the respondent number 6 particularly is a judgment of this honorable court that your lordship will find there is an IA file for vacation. This is in respect of the same respondent number 6. There was a challenge made in connection with another selection in another college. This was perhaps, if I remember correctly, this was a college in Nagaon. This was a college in Nagaon. The same certificate was doubted, but in a different context altogether, not in the context of this 2004 OM that I have placed. Your lordship will find that doubt has been sought to be erased, but not in the context of the 2004 OM. And therefore, at the very beginning, I had submitted that this is a judgment so far as this particular OM and this particular submission that I am advancing. It is sub silentio. Not only per incuriam, it is sub silentio. Because this aspect was never brought to the notice of this honorable court. So how can this judgment bind your lordship? If your lordship goes through the as an officer of the court, with all sense of responsibility, I am making this submission. This OM of 2004, which prohibits engagement of anyone against non-sanctioned posts, non-existent posts, was never even brought to the notice of this honorable court. And dehors that OM and dehors this submission, this case has been answered. If your lordship will first come to page 27 of that IA, para 6, what was put to challenge is this para 6, the last sentence. This certificate was doubted, and the contention advanced is that the respondent number 6 did not render service for 1 year in the aforesaid Mahendra Narayan Chaudhary Balika Mahavidyalaya. To that extent, the entire question was confined to this extent. And this doubt was negated by this honorable court. At page 29 is the issue that fell for consideration. Para 14. The question that has emerged for consideration is whether the respondent number 6 was sought to be given undue benefit on account of experience by the respondent number 7 demonstrated by the certificate issued by him in favor of the respondent number 6 of the writ petition. And that has been answered The Honorable Court looked at the records, found that some salary was drawn from so and so month to so and so month, etc., and accordingly held that we are negating this doubt. But even after negating this doubt, the challenge in this particular case starts from that stage, even assuming that doubt stands negated. Still, that 1 mark could not have been awarded for the simple reason, by virtue of this OM of 2004 at page 30 that I had placed before your lordship, that 1 mark could not have been awarded. Now, your lordship is aware of the law relating to precedence. If your lordship will permit me, I'll just place a couple of judgments as to how a precedent is to be understood. If your lordship will first have 2003, volume 7, SSC 197. Book list, yes.
Yes.
Your lordship will straight away come to para 23.
Yes.
So far as Nagesha case relied upon by the claimant is concerned, it is only to be noted that the decision does not indicate the basis for fixing of the quantum as a lump sum was fixed by the court. The decision ordinarily is a decision on the case before the court, while the principle underlying the decision would be binding as a precedent in a case which comes up for decision subsequently. Therefore, while applying the decision to a later case, the court dealing with it should carefully try to ascertain the principle laid down by the previous decision. A decision often takes its color from the question involved in the case in which it is rendered. The scope and authority of a precedent should never be expanded unnecessarily beyond the needs of a given situation. The only thing binding as an authority upon a subsequent judge is the principle upon which the case was decided. Statements which are not part of the ratio decidendi are distinguished as obiter dicta and are not authoritative. The task of finding the principle is fraught with difficulty, as without an investigation into the facts, it cannot be assumed whether a similar direction must or ought to be made as a measure of social justice. Precedents sub silentio and without argument are of no moment. Mere casual expressions carry no weight at all, nor every passing expression of a judge, however eminent, can be treated as an ex cathedra statement having the weight of authority. So, what I'm specifically relying on is this sentence, my lord. Precedents sub silentio and without argument are of no moment. So, in the judgment that is sought to be relied on, this point was not even before the Honorable Court. It was not even, the 2004 OM was not even placed, and arguments on the basis of the 2004 OM were not even made before the Honorable Court. So therefore, that cannot serve, that judgment cannot serve as a binding precedent for the purpose of deciding this case. Another judgment that I would like to rely on, basically on similar grounds, but slight improvement on it, my lord. This is 2006, volume 6, SCC 366.
Yes.
The relevant paragraph is para 13. The High Court, unfortunately, did not discuss the factual aspects, and by merely placing reliance on an earlier decision of the court, held that the reinstatement was mandated. Reliance on the decision without looking into the factual background of the case before it is clearly impermissible. A decision is a precedent on its own facts. Each case presents its own features. Your Lordship may skip that portion, my Lord. It's a very longish paragraph. Towards the middle, Your Lordship will find a sentence, my Lord. Sentence starting a decision, as my Lord got it. A decision is an authority for what it actually decides. What is of the essence in a decision is its ratio, and not every observation found therein, nor what logically flows from the various observations made in the judgment. The enunciation of the reason or principle on which a question before a court has been decided is alone binding as a precedent. A case is a precedent and binding for what it explicitly decides, and no more. The words used by judges in their judgments are not to be read as if they are words in an act of parliament. In so-and-so versus so-and-so, so-and-so observed that every judgment must be read as applicable to the particular facts proved or assumed to be proved, since the generality of the expressions which are found there are not intended to be exposition of the whole law, but governed and qualified by the particular facts of the case in which expressions are found, and a case is only an authority for what it actually decides. So in the case on which the reliance is being based on, it did not actually decide the consequence of the OM of 2004. The effect of banning of engagements against non-existent posts was not gone into. The Honorable Court, naturally, since it was not placed, the Honorable Court stopped at the doubt that was expressed with regard to this certificate. To that extent, it may be binding. But beyond that, to stretch it and to say that this judgment will cover this case also, it will be stretching it a little too far. There is another judgment, my Lord, where the apex court has specifically said that even a little difference in facts takes away the precedential value of the earlier judgment. I'll quickly place that 2003, volume 2 SCC, 111. Para 59. It's a very short paragraph. It reiterates the earlier judgments to the effect that a judgment is a precedent for what it actually decides. Here, one further sentence has been added. A decision, as is well known, is an authority for which it is decided, and not what can logically be deduced therefrom. It is also well settled that a little difference in facts or additional facts may make a lot of difference in the precedential value of a decision. So, therefore, in my respectful submission, my Lord, what your Lordship is called upon to decide in this particular case is the effect of even assuming those certificates are taken on their face value. What remains to be adjudicated is the effect of the 2004 OM and whether the respondent number 6 will be entitled to that at 1 mark. And that is the decision-making process that is under challenge before your Lordship. So therefore, the argument that it has not gone to the director, therefore it is premature, would also not hold good. We are questioning the decision-making process adopted by the selection committee. Therefore, my Lord, in my respectful submission, that 1 mark has to go. And if that 1 mark goes, I come in. Subject to what my learned friends submit, my Lord, reserving my right of reply. That's the, in a nutshell, that is the case before you.
My brother will pass on.
Mid legal lodge. My Lord,
My Lord, can I be excused for 5 minutes?
My Lord, we have filed an interlocutory application for vacating the stay. However, my lord, since the vacation of the stay would have rendered the writ petition infructuous, it was agreed upon that it would be taken as the affidavit of question and the entire matter would be disposed of. Lordship will kindly take up my IA, my lord, 3505 as my counter affidavit in this matter. 3505 of 2022. Yes. My lord will now kindly come to page 18, that is the interim order. Interim order is dated 11/5/2022. Lordship will kindly turn to page 20. And third paragraph from the top, my lord. In this writ petition, the petitioner raises an issue that 1 mark was incorrectly given to the respondent number 6 to so and so in the selection process for the post of assistant professor in Sanskrit in Nalbari College, Nalbari. It is stated that if 1 mark would not have been allotted to the respondent number 6, a right would have accrued in favor of the petitioner for a selection. It is further stated that the records of selection have already been sent to the authorities in the higher education department for its approval. Also, will kindly mark what was stated before this honorable court for obtaining an interim order matter. I'm reading again. It is further stated that the records of the selection has already been sent to the authorities in the higher education department for its approval. Considering the stage of selection process, in the interim, we provide that status quo as regards the appointment to the post of assistant professor in Sanskrit in Nalbari College, pursuant to the selection held on 25/4/2022, shall be maintained until further order. So, my lord, records will reveal that selection process is yet to be completed because in the writ petition, no foundation has been laid as to what marks the petitioner has got or what marks the private respondent has got. Only after the selection committee finalizes the selection, it places it before the governing body. And the governing body sends it to the director of higher education for approval. After that approval is granted, only, my lord, then the cause of action arises. Now, my lord, there is in the writ petition no whisper regarding the marks which they have got or we have. How come the petitioner knows that he has got 1 mark less than me, my lord? Where from she is saying so, my lord? There is nothing on the writ petition. Now, my lord, I will straight away take your lordship to that judgment of this honorable court. And then I'm come back to the OM, my lord. Lordship will kindly turn to page 25 of my IA. The issue is already decided, my lord. With all sense of responsibility, I'm saying so, my lord. Here, my lord, a similar post in Nagaon College fell vacant, my lord. Assistant Professor Sanskrit, same department, same post, my lord. Only, my lord, there the candidate was different, who challenged my 1 mark granted to me in view of my teaching experience. And, my lord, this honorable court called for the records from the Nalbari College to see whether I have served or not. And from the original records, it found that I had drawn salary as an ad hoc teacher, my lord, and for 1 year. That's why, my lord, I can read from the paragraphs, my lord, I'm not troubling, but it is mentioned, my lord. So, upon perusal of the records, original records, this honorable court came to the satisfaction, no, yes, the private respondent number 6 has rendered her services and she has obtained her teaching experience. Therefore, she is entitled to that 1 mark reflected in that OM, my lord. Now, my lord, having come to that conclusion, whether this honorable court in a coordinate, sitting in a coordinate bench, can overturn this decision, my lord.
So was 2004?
Yes, I'll straight away come to that, my lord. Now, the contention of my learned senior is that at the relevant point of time, there was a ban operating in appointment in sanctioned posts. Now, my lord, the Honorable Supreme Court time and again has held that teaching experience, whether gained in a sanctioned post, permanent post, or an ad hoc post, it doesn't matter. Teaching is teaching and experience will count, my lord. Also, will kindly take up 1983 volume 1 SCC. Page 345, 1983 volume 1 SCC. Well, I'll hand over the book. I'll just read one paragraph very slowly. 1983, volume 1 SSC, page 345. Para 29. Name of party is Asim Kumar Bose versus Union of India. Asim Kumar Bose versus Union of India. Para 29, my lord. It is necessary to emphasize that the recruitment rules nowhere provide that the teaching experience gained by a specialist in a teaching hospital in the capacity of an associate professor ex officio shall not count towards the requisite teaching experience. My lord, will kindly mark this word, my lord. There is no provision made in the rules that the teaching experience must be gained on a regular appointment. There is hardly any difference. So far as teaching experience is concerned, whether it is acquired on regular appointment or as a specialist in a teaching hospital with an ex officio designation. As the statutory rules do not provide that teaching experience gained in an ex officio capacity shall not count towards the requisite teaching experience. The teaching experience gained by the appellant while holding the post of radiologist cum associate professor in radiology ex officio in the Interim hospital cannot be ignored in determining his eligibility for appointment as a professor in so. So here, my lord, this particular petitioner, he gained his teaching experience in an ex officio post, my lord.
No, that's fine. According to that,
My lord.
as per the rules, there's no.
There's no here also, my lord. Here
No,
only
here
there
there's an office memorandum
office memorandum.
banning appointment on non-sanctioned posts.
Yes, my lord. I am not saying that my appointment was permanent. It was an ad hoc appointment only. An ad hoc appointment can be given. And if at all, my lord, there was some illegality, then my lord, that will not, my lord, denude me from getting my right under teaching experience. It may entail certain action against the authorities. But here we are talking about the experience gained from teaching, my lord. Even if my appointment was not in terms of the OM, my lord, then also, my lord, the experience gained from teaching, that cannot be denuded, my lord.
No, when there's a ban
Yes,
for appointment,
yes, my lord. For
now, if you
appointment,
are appointed the horse the ban,
my lord.
then your appointment becomes immaterial.
No, my lord. Doctor will kindly see, there was a ban for permanent appointment. Doctor will again come to that OM at page 30, my lord. Page 30 of the petition. Subject, prohibition of acknowledgement of teaching and not teaching staff in deficit granting aid college without sanction post. In continuation of this department, so and so, the following procedures formality are prescribed for banning the appointments of teaching, non-teaching staff against non-existent posts in deficit granting aid college. Henceforth, no college under deficit granting aid shall engage any person for teaching or non-teaching work where no sanction post exists for the purpose. For the purpose of filling up vacant sanction posts, existing government instruction guidelines will be responsible for any violation of the above sanctioned conditions. All members of the governing body of the college, including the principal secretary of the college, will be responsible for any violation of the above mentioned conditions. The member secretary of the respective colleges shall invariably submit reports of compliance of the above conditions twice in a year and in the second part of 1st of April and a report on so. So, my lord, there is a ban that you can't make any permanent appointment if there is no sanction post.
Where is the word permanent?
My lord, sanction post, my lord, sanction post is synonymous with permanent appointment, my lord.
Sanction post also you can have an ad hoc appointment. There's no issue in that.
Yes, my lord. My lord, it is a fact that the petitioner was engaged on a temporary basis for an ad hoc appointment.
Against non-sanctioned post.
Against non-sanctioned post, my lord. And she gained that experience, my lord.
No, that is why when there's a ban on in the year 2004.
True.
Now, whether you could have been appointed.
Even assuming I could not have been appointed, then this will not nullify my teaching experience. That is my humble submission before this honorable. Because I have gained the teaching experience and this honorable court having upheld, my lord.
No, upholding that judgment.
My lord.
The judgment, in the judgment, that 2004 was not considered.
This OM was not placed. True.
That particular judgment was with regard to the authenticity of your teaching experience for 1 year.
True, my lord.
So after going through the records, it was found that yes, you have drawn your salary for more than.
Well, I have worked and that's why I have gained my experience.
So that is one issue.
Yes,
Now, the issue that is brought up today
my lord.
is that when you have been appointed on the basis the whole the OM of 2004,
My lord.
therefore your appointment becomes immaterial, and therefore you are not entitled to get that 1 mark.
No, my appointment may, my lord, at that point of time, had he challenged, it would have been cancelled, that's a different thing. But I continued to work, I gained the teaching experience, that's why I was issued the experience certificate.
So you continue to work, that's not an issue.
Yes, my lord.
But then that was against the OM, against the instruction of the government.
Maybe, my
So
lord, but
therefore, when your
for
appointment is,
violation of this OM, it does not say my teaching experience will go. It says action will be taken against the authority, my lord. If there was any violation, assuming there was violation, my lord, then it entails action against the authority. But the teaching experience will not go, my lord, in my humble understanding. My lord.
that we'll have to consider. Our thing is when you have been appointed yours 2004 OM, then obviously your experience becomes immaterial, and therefore that 1 mark would not have been given to you. That's I think. You can think about it.
Yes, I'll satisfy on this point, my lord, because
See, that one issue is you are saying
I've understood, my lord,
this court has already decided the matter
Yes.
with regard to 1 mark.
regarding my experience.
That there's no argument on it.
True, my lord.
So far as your experience of 1 year,
It's
there's
okay.
no argument on it. But the issue is when deciding that 1 mark, that OM was not considered.
Yes, that was not placed,
That is one.
my lord.
Therefore, that the reliance that you are making in this court's order
Right.
may not have any application in the present case in hand, because now the petitioner has raised an issue that the 2004, when there is a ban on 2004 recruitment to non-sanctioned posts.
My lord.
Therefore, when you have been appointed, divorce the ban. Now, divorce the OM.
My
That
teaching,
your teaching experience becomes
Becomes that-
immaterial, and then therefore you could not have given that 1 mark.
understood, my lord.
And the second issue is that they're challenging the decision-making process
Right.
of the selection committee. Not that these are two
Yes.
issues involved. If I'm not wrong, I think these are just 2 issues involved.
Yes, my lord, then I'll address in your lordship, my lord, regarding that OM, I'll look into some more judgments, my lord, because this judgment clearly says, my lord, whether the experience gained in a permanent post or ad hoc post is the same, my lord.
That judgment, I've not gone through properly, but then I was listening to you.
Right.
It says in the rules.
Is there in
There's
the,
in the rules, there's no provision,
no problem,
whether it is against
permanent or,
permanent or sanctioned. Here, there's a ban. That's all.
my lord, will give me some time, I'll try to satisfy your lordship whether, let's see whether some
But
judgment.
I, Chowdhury, Learned Senior Counsel, assisted by Mr. S. Hazarika, Learned Counsel for the petitioner. On request made by Mr. J. Patwari, Learned Counsel for respond number 6. Please the matter after
2 weeks.
2.
Your lordship will keep it parted because virtually the arguments are over. Even what has been submitted by my learned friend, I can answer straight away. The word used in the OM is engaged, which means any kind of engagement. If your lordship sees the OM for a moment, if your lordship comes to page 30, second paragraph, henceforth no college under the deficit grants in age system shall engage any person. Engage, it does not talk about even appointment. To construe that it talks about only permanent appointment. And the submission advanced that even if it is divorce the OM, I have gained the experience. The fact remains that it remains an illegal engagement. And this honorable court in exercise of jurisdiction under Article 226 does not perpetrate illegalities. That is the answer to the submission advanced. Otherwise, my lord, I don't think anything more can be elaborated.
As part. Deeply.
Obliged.
Eight, 9, and 10.
Lordship, may I please, your lordship, appearing on behalf of STKL for Assam University, your lordship. He had some injury in his leg, so he could not prepare the case today, your lordship. So may I pray matter may be taken up any date next week, your lordship. Maybe on
Maybe
Thursday,
fixed
your
on 3rd of August.
Third, I have fixed a lot of cases.
Then on 8th, lordship, 8th of August. Sir.
The MS,
Yes, Dev.
third MS S Dev,
Yes, sir.
Learner Counsel for the petition. On request made by MS,
Ardeka.
R.
Ardeka for Assam University.
Learner Standing Counsel.
No, your lord, I'm on behalf of Mr. STKL, who is the standing counsel.
Learner Counsel appearing on behalf of Mr. S.C.K.L. Learner Standing Counsel Assam University. This is the matter. We'll have it on 10th.
Lordship, 10th.
10th.
Obliged, your lordship.
Lordship, 10th, there is some urgency, there is some problem, Lordship. On 11. Lordship, I'll fix the date later. I'm asking my senior. But 10th, he has some problem, Lordship. I'll just let you know within a minute.
Just check up and come back. You wait for some.
11 and 12.
Your lordship, Mr. Nair is on next in division bench. So I pray that the matter may be passed over for timely knowledge.
We'll see any other day. I have the division bench on part of hearing. So any other day. Any other day.
On request made on behalf of Mr. Nair. This the matter after 2 weeks.
Let's.
2 weeks.
Oblige, lordship.
Highly obliged.
13.
May I please, your lordship? Here in this case, my lord, 13 and 14 are similar matters, my lord. Regarding, my lord, appointment of a gazetted teacher, my lord, we have challenged the advertisement where, my lord, we are the overage, my lord, at the being the TET teachers, my lord, here.
Affidavit has come.
Yeah, affidavit has filed, my lord, and we have filed the reply also, my lord.
1 minute.
Yeah, affidavit, my lord, kindly peruse filed by the, my lord, respondent, my lord.
What?
They have did not mention about anything, my lord. Simply they have said that we are not going to give the, my lord, appointment, my lord, condone the delay of the, my lord, age of the petitioners, my lord. It's basically on the, my lord, condonation of the delay of condonation of the age of the petitioners, all the petitioners, my lord. And the earlier one case is filed by the some of the similar situated petitioners, my lord.
Which you reply affidavit?
What way? My lord, it is not in the record, I guess, my lord. We have filed on the Monday, my lord.
Oh, it's not on record.
In our file also, reply has not come, my lord. So, one time.
In that case, your lordship will have for any other date.
Okay, Mr. Hai Chaudhary, City County for the petition supports that I file a reply to the counter affidavit filed with the respondent number 1 on Monday.
Monday, my lord.
On 24th. July 20. Registry to verify and place the same on report, comma, to count in order. This after 1 week, 2 weeks.
Operation. The lordship can have it on 10th one.
Okay. $10. Item 14 also same?
Same.
Yes.
Same.
You file your reply here.
My lord, not on item number 14, we have filed, 13, we have not filed. My lord. This is the same, my lord, affidavit, same stand has been taken, my lord. Therefore, we have filed.
Oh,
in one.
item 14 you filed,
Yes, my lord.
not in item 13.
Not in item 13. my lord. In Susil Soria, my lord, petitioner, we have filed the affidavit in reply.
Oh, then cancel that order. Then the council, senior council. Also had you Shamal and also. For which department?
Secondary education.
Is the matter of 10.
10.
And in this item 14, you say. Mr. Chowdhury, let's see, council suppose that yes, filed an affidavit reply to be counter filed by this number 1. On 24th July. Registered to verify and place the same on record. He found in order. This is the matter of that. It's one.
Yes, Lordship, let it be on 15th of August.
15, ma'am.
15th of August.
Sorry.
I'm having a holiday on that.
Sorry, no, 15th of August. 17. 17, ma'am. 17.
17th August.
15.
Wait, please, Your Lordship. Yeah, the petitioner challenged the impugn order at page 31, my lord. Page 31. I am reading, my lord. Due to non-compliance of RTI information from the authority concerned, Sri Abdurrahman HT Uttar Pata LP School is hereby removed from the HT CAM member secretary of the state school with immediate effect, and Mr. So-and-so is hereby allowed to act as head teacher. My lord. Then, my lord, come to page 19, the RTI application. One Bilal Hussain has filed an RTI application, my lord, by seeking some information, my lord. Page 19. Filed on 13/9/2022. Accordingly, my lord, we have filed the reply, my lord, on page 22. Page 22. 1/10/2022, we have filed the reply. My lord, 1, 2, and 3. Then, my lord, on being satisfied by the Bilal Hussain, my lord, he has filed an appeal, my lord, before the authority, my lord, at page 23. Accordingly, the first appellate authority issued a notice, my lord, fixing the date on 30/11/2022 for hearing. Then, my lord, we also appeared in the hearing, my lord. Subsequently, my lord, page 25, show cause notice was issued, my lord. My lord, I am reading the show cause notice. As per report of Mizanur Rahman Bhuya, this is issued by the BO, my lord. As per report of Mizanur Rahman Bhuya, SPIO, Office of the Block Elementary Education Officer, Bilashivara, it has come to my notice that a hearing was conducted on 30/11/2022 regarding RTI 2005 information. In that hearing, you are admitted before the undersigned the required information of the said school will be submitted to the office of the undersigned on 5/12/2022. As on today, you are again failed to submit the report information to the undersigned. This is the show cause notice, my lord. You are hereby asked to submit a reasonable reply to the office of the undersigned within 3 days. Then, my lord, I have submitted the reply, my lord, page 26 and 27. Page 26, my lord. With due honor, I state as follows. That on 13/9/2022, one Bilal Hussain, son of so and so,
filed a petition seeking some information from the office of the head teacher of Uttur Suhapata LP School. Accordingly, he was replied on 1/10/2022. Already replied, my lord. Against his RTI petition dated 13/9/2022. After being agreed on said reply, he initiated first appeal before the SPIO office of the BO Bileshwara, and the SPIO issued a letter on 28/11/2022 for first appeal hearing on 30/11/2022 without enclosing the first appeal petition of the said petition. Though hearing was conducted and oral instruction was. Yes, my lord. The first appeal was initiated before the BO, my lord, but the impugn order has been passed by the DO, my lord. My lord, again come to page 31, my lord. Impugn order was passed by the DO. When the first appeal was conducted by the DO, my lord, how the DO has passed the impugn order, my lord. That part, my lord, the first appellate authority only has the power to, my lord, dispose of the appeal. Nothing more, my lord. But he has imposed the penalties, my lord. My lord, now come to section 19 of the RTI Act.
1 minute.
RTI Act 2005, my lord, section 19. RTI Act, Right to Information Act 2005. My lord. I am reading, my lord, section 19. Appeal. Any person who does not receive a decision within the time specified in subsection 1 or clause A of subsection 3 of section 7, or is aggrieved by a decision of the Central Public Information Officer or the State Public Information Officer, as the case may be, may within 30 days from the expiry of such period or from the receipt of such a decision, prefer an appeal to such officer who is senior in rank to the Central Public Information Officer or the section 19, my lord.
Yes.
Appeal. 1, my lord, 19(1). Any person who does not receive a decision within the time specified in subsection 1 or clause A of subsection 3 of section 7, or is aggrieved by a decision of the Central Public Information Officer or the State Public Information Officer, as the case may be, may within 30 days from the expiry of such period or from the receipt of such a decision, prefer an appeal to such officer who is senior in rank to the Central Public Information Officer or the State Public Information Officer, as the case may be, in each public authority. Then, my lord, he has already filed the first appeal before the BO, my lord. Then the jurisdiction of the first appellate authority, my lord, subsection 6. An appeal under subsection 1 or subsection 2 shall be disposed of within 30 days of the receipt of the appeal, or with such extended period not exceeding a total of 45 days from the date of filing thereof, as the case may be, for reason to be recorded in writing. This is the only jurisdiction to dispose of the appeal, my lord. And section, my lord, 20, penalties may be imposed by the second affiliate authority, my lord, the commissioner, in the second appellate stage, my lord, not by the first affiliate authority. And in this case, my lord, the appeal was preferred before the BO, and hearing was conducted by the BO, but the impugn order has passed by the DO. He neither the first appellate authority nor the second appellate authority, my lord. My lord, BO is the first appellate authority.
No appellate authority would have no jurisdiction to issue the impugn order.
Yes.
The district elementary education officer issued, maybe was any notice issued to you?
Yes, my lord. Notice was issued, my lord.
By whom?
But initially, notice was issued by the BO, my lord. My lord, come to page 23, my lord. This is the notice, my lord, issued by the BO, fixing the date on 30/11/2022 for hearing of first appeal. My lord.
That's a different matter.
Yes, my lord.
After that,
Thereafter, my lord, the DO again issued notice, my lord, another notice, my lord, at page 28. And assuming, my lord, the DO also the, my lord, first appellate authority, he has only power the dispose of the appeal only, my lord. He has no authority to impose any penalties, my lord. Only penalties can be imposed by the commissioner in the second appellate authority, my lord.
appeal thing is a different issue.
Yes, my lord.
That appeal process will go on.
Yes.
But this is a thing because you have not done your part,
Yes.
that this action is taken.
Yes, my lord, I have done, I have already, my lord, given the reply, my lord. Page 22. Page 22, against the RTI petition.
No, not this.
Again, my lord, I have filed the reply, my lord, against focus notice base 26 and 28, 7, my lord. 26 and 27.
Yes, Kaushik.
My lord. My lord, the consequence of the RTI could be different, my lord. The lordship finds page 25 the so cause notice. This is not a penalty under the RTI Act which has been imposed, my lord. Page 25, he has been so cause, my lord. Third line, my lord. You are admitted before the undersigned that the required information of the said school will be submitted to the office of the undersigned on 5/12/2022. He disobeyed the authority's order, my lord. Now his reply at page 26. He admits that he has not submitted the document. And moreover, my lord, the head teacher in a LP school, my lord, it's not a substantive post, my lord. Out of the two teachers in the LP school, one is given the charge, and for that he gets 300 rupees for acting as a head teacher. So it is not even a punishment, my lord. But as being acting as a head teacher, he holds.
You make your stand clear by way of an affidavit.
My lord.
That's the whole thing.
fact, I was awaiting instruction, my lord, where I was
You have not received
not
instruction.
received, my lord. I communicated yesterday
It's
also.
a
my lord.
small matter.
Yes, yes, but
And
because if your lordship finds the 1981 rules, lordship will find page 316 in this book. my lord. There is no post as head teacher in an LP school. my lord. The person who is given a charge, my lord, out of there are 2 teachers in an LP school. The one who has been given a charge, he gets 300 rupees, and that's not a permanent post. So this cannot be treated as a penalty, my lord, demotion. He projected that he has been demoted.
what?
My lord, on 31st of this month, my lord, the petitioner is going to be retired, my lord.
That will not affect me.
31st of July, my lord.
That is not going to affect you.
Anyway, he's in service. He's in service.
But my lord, my submission is, my lord, the DO has no authority under the RTI Act to issue such kind of order, my lord.
It is not
Because, my lord,
This is not an order
Penalty
under
under
the
the
RTI.
Yes.
This is an administrative act.
absolutely. my lord.
yes, but it was issued on the basis of RTI application, my lord.
Exactly.
As a
Just submit on
consequential
time.
order of RTI application, my lord.
So that notice was given to you,
Yes,
not by the appellate authority.
yes.
The notice was given to you by through a way of an administrative
Yes, by the appointing authority.
appointing authority.
Yes. But
It's not under the RTI.
yes, my lord,
You are getting
I-
confused.
my lord,
RTI is a different line. Let us not get
Yes,
involved with the
that is-
RTI.
It is not a penalty under the RTI.
my lord, kindly come to page 28. This is the notice issued by the district elementary education officer, my lord. Thereafter, the impugned order has passed. My lord, I am reading, my lord. Block elementary education officer Bileshwara, head teacher so-and-so, Belal Hossain so-and-so. Sir, madam, in enclosing here with a copy of letter so-and-so dated 6/1/2023.
That
Along,
I've seen, that I've seen.
yes,
Yes, you.
This is parallel procedure.
Elementary education department is allowed 1 week time.
2 weeks, my lord.
Allowed 2 weeks
Filed by
time.
affidavit.
Please, again.
my lord, already 3-4 times has gone, my lord.
Please, the matter of 2 weeks.
Highly recommend.
29 and 30 admission.
Meet. In the connected repetitions, the pleadings are complete. I had also filed IA in both the repetition. There has been no reply from them as on date. If your lordship desires, I can start with the,
What IA? How many IAs have you filed?
in both the repetition, one individual IA to show that while the matter is pending before this honorable court, the opposite party number 6 is seeking to curtail the jurisdiction of this honorable court.
Diane, are you filing any reply to the IA?
That is not the part of this petition, my lord, and I will not file any reply. That the main petition may be hard to take, my lord.
How about the IA?
IA is, my lord. But IA is not related to this writ petition.
If
my
they
lord.
don't
The
wish to
subject
reply,
matter
that's
is
all right.
different.
I
Subject
can
is
proceed
different.
with my
Different,
argument.
my
It's
lord.
up to you. If you want to file a reply, then I can give you time.
Yes, my lord.
Otherwise, if you're not interested, there's a different issue.
Yes.
IA is related to the writ petition, isn't
Correct.
it?
Yes, but
It is-
subject matter is not related to this writ petition, my lord. That subject matter is different from this writ petition. That this writ
But
petition may be heard.
there's already an allegation made in the IA, isn't
Yes,
there?
my lord. Yes, allegation.
Are you going to rebut that allegation or you're going to accept it?
No,
That's
my
the
lord.
whole issue.
If she doesn't wish, why not? I can proceed
Yeah,
with
if you don't wish, that's a different thing.
My lord, then I'll file that objection in this IA, my lord. That but matter may be fixed on the short date, my lord.
Short term.
Short date, my lord. Today is Thursday, my lord. Monday, my lord. I'll file it by tomorrow, my lord.
Heard Mr. A.K. Barwa, learned counsel for the petitioner. M.S.A. Gayan, learned standing CGC,
CGC, ma'am.
appearing for respondent 1 to 3.
Okay.
Press for a short time to enable her to file objections in IA
Malad 2030 of 2023 and
2030 of 2023 and 2032 of 2023. List the matter again on Monday.
Monday, my lord.
Monday, there's a difficulty. is there?
I'll also need to file my reply subject to what they say. So let the matter come up
There is nothing but
uh,
delay of my lord.
in some time so that I can also file my
No,
reply.
my lord, I am saying, my lord.
After
There
a
is
week, I'll give, after a week. List the matter after 1 week.
my lord, date may be fixed, my lord. 3rd of, my lord, 3rd of August, my lord.
Fourth.
So interim protection is there. no?
My
That
lord,
may
3rd
be-
of August.
Fourth.
Or in the Your Lordship can have it on 8th. It's a hearing.
No,
day.
my lord, 4th of August, my lord. Because we are in urgency, my lord, they are trying to delay the matter, my lord.
Interim protection earlier. Obliged, deeply obliged.
Lordship, we have been appointed as an MI. We do.
Oh, also, amicus curiae. Also heard MS D. Boyan, Leonard amicus curiae.
Obliged, deeply obliged.
16, 17 and 18 of Delhi list ordered.
May it please your lordship. Well, this case your lordship has heard in land. The petitioner is serving as a doctor, my lord, in the Health and Family Welfare Department. At page 72, if your lordship looks, your lordship will recall. He is presently working as an assistant professor of dentistry, my lord. Page 72, your lordship will, then your lordship will recall. Page 72, assistant professor, my lord, your lordship will find. Dr. Alpana Talukdar, assistant professor, Dr. Alpana Talukdar, she is unreserved petitioner, would have been eligible but for non-submission of ACI for the year 2016 as per record of DME. The next senior most incumbent, Dr. Bhaskar Das, respondent number 5, Dr. Rajashree Bora, respondent number 6, and Dr. Ornima Goswami, respondent number 7, may be promoted to the post of assistant professor. I am the senior, and Rajashree Bora's also APR was not submitted as per the office memorandum within 31st of January 2019, my lord. And your lordship will recall that at first page itself of the minutes at page 69.
Whose ACA was not submitted?
No, APR was not submitted, also of respondent number 6 who have been considered for the promotion, my lord. And your lordship will recall at page 69. So far property details are concerned, my lord. Is service to just office, my lord. I may reply. And your lordship will recall at page 69. The IPR for 2018 is only required. IPR to
2018.
Only 2018 IPR was required, and DPC was held on 30th of August 2019. 30 DPC was held on 30th of 2019, and this IPR for 2018 was before the authorities on the date when the DPC was held. That your lordship will find at page 77. Serial number 7, my lord. Serial number 7, TMC. TMC is Tezpur Medical College, Dentistry, Register, Dr. Alpana Talukdar. Then annual property return statement submitted for the years ending. Yes, my lord. You also got it at page 77. Then you'll also see on the day when this DPC was all, the APR was also there. Now I have been given promotion, my lord, on this that page 69, my lord. Your lordship will find the date was 30/8/2019, and my lord, I was given promotion on 17/12/2010. That your lordship will find at page 80. Just to refresh it, my lord, your lordship has already looked into it. Only for your Page 80, my lord. I was subsequent when this matter was sub judice before this court and it was pending. Just like the other day, your lordship has given them the option that you may consider in spite of this cases pending. So they have been then in the next DPC, my case was considered on 17 December 2010, serial number B, my lord. I have been promoted as assistant professor. So my prayer at this moment is only that I should be given notionally the benefits of promotion when my juniors were given promotion in the DPC of that at page 72. First, from that date, your lordship will find at from which date I am claiming, your lordship will find at page 58. That is date is 1st November 2019. From that date, I am claiming my page 58, my lord. The notification starts at page 58.
Yes.
My lord, numbers of doctors have been promoted, and your lordship will find at page 59. The bottom one is the respondent number 5. Page 59, the bottom, the Bhaskar Das, respondent number 5. In this case, your lordship has specifically asked them that among these 3 doctors who have not submitted the APR, it did not even strike my mind. It only when your lordship asks them to produce when they have submitted, then they said that yes, one of the respondent who has been promoted was also not, sir. Maybe in this list, my lord, where several doctors have been promoted, many of them may also have not submitted the APRs. But I am not on that, my lord. I am only that no prejudice will cause to any of the parties if I am given notionally the benefits of the promotion, and all my calculations should be done on the basis of this 1st November 2019. And in the gradation list at page 68, your lordship will find that I am the senior most professor at page 68, my lord. There was no lashes or negligence on my part. Your lordship has heard it, but only to refresh it, my lord. Page 68. Page 68, my lord. Serial number 12 is the petitioner, my lord. Serial number 12 is the petitioner, my lord. Your lordship will find I became eligible. I became a registrar on 19/3/2015. Dr. Bhaskar Das, respondent number 5, serial number 13, 10/2/2016. Dr. Rajeshri Bora, respondent number 6, 2/5/2016. Dr. Mrs. Onima Goswami, respondent number 7, 15/3/2017. Now, if my date is not counted from the day when from 1st of November 2019, then even when at the next post my promotion will be considered, they will supersede me, and again I will be discriminated. So on the last option, your lordship gave an option to them to consider it in on their own. And if your lordship they then don't wish to consider it on their own, then your lordship will give a specific direction to consider my case in terms of that 111 when Bhaskar Das was promoted, my lord. That's my humble submission.
May I plead the lordship, my lord? We have filed an affidavit in 8/2/92 of 2019 in the writ petition. So that will cover the cases, my lord. The basic our stand is that, my lord, the petitioner did not submit the APR in due time, my lord. Affidavit filed by the respondent number 1, my lord, on behalf of respondent number 1.
Yes.
Thank you.
My lord, in the affidavit at page 16, my lord, annexure 3, my lord, page 16, 16, my lord. Affidavit. It is a office memorandum issued by the Department of Personnel, my lord. Submission of annual property return statement by class 1 officers of Government of Assam. Instances have come to the notice of the government that government servants sometimes do not submit immovable property returns to their respective appointing authorities. The Rule 11(1)(a) of the Assam Civil Services Conduct Rules 1965 has specified that every government servant is to submit return of immovable property inherited by him or owned or acquired by him or held by him on lease or mortgage, either in his name or in the name of any member of his family or in the name of any other person at such intervals as may be specified by the government. It has been therefore decided that all officers of government of Assam shall submit their annual property returns in two separate formats, namely immovable property return and another for movable property return, henceforth regularly latest by 31st January every year. 31st January every year to their respective appointing authority or disciplinary authority. Next point, it has also been decided that officers of government of Assam who do not submit the annual property return statements in time would be denied vigilance clearance and will not be considered for promotion. Empanelment for senior level posts under the government, the deputation to foreign service, etc. So, my lord, in the instant case, my lord, the DPC was held on 24/7/2018. So, my lord, in terms of this office memorandum, the petitioner had to submit her IPR by 31st January 2018, my lord. Only then her case may be considered. So now, but my lord, if your lordship peruses Annexure 11, page 14, my lord, of the affidavit, your lordship will find that the petitioner submitted the APR on 5/8/2019, my lord. 5/8/2019. So, my lord, since she did not submit the IPR in terms of the notification of the personnel department within January of that year, my lord, so her case could not be considered, my lord.
Yes.
When did respond number 6 submit?
Well, that date is there, my lord, a concern instruction. It was submitted on, my lord, repetition content. Repetition content. Notification. It was submitted on, my lord, just a moment. It was submitted on 3/6/2019. Respondent number 5 or 6, Dr. Rajeshwar Bora, submitted on 3/6/2019, madam. Well, basically, what I understand from my learned friend is that my case was not considered because in terms of the office memorandum, I have to submit it on within 31st of January 2018. But as your lordship has noted in the earlier hearing, that when the DPC was held, that was there. And to reply to this short submission, which my learned friend has referred, I had made all those facts clear in paragraph number 5 of the affidavit in reply to the respondent number 1 in WPC number 8292, my lord. My lord, factually, nobody is disputing the dates, my lord. Even I am not disputing the dates. Affidavit in reply to the respondent number 1, your lordship will find at page 63. Page 63, your lordship got it, running page, paragraph number 5, my lord. Just here, further, the deponent states that the promotion of the deponent were not taken into consideration due to the belated submission of the ACR for the year 2016 by the respondent. The APRs of the deponent for the 11 years were submitted before the DPC, which were held on 30/8/2019. That means 2018 APR. The contention raised in regard of late submission of API in terms of the office memorandum dated 5/2/2014 is an afterthought to cover up the lapses and negligence of the departmental authorities. Nowhere in the minutes of the DPC and the records it is reflected that due to late submission of the API of the deponent, her case was not considered for promotion. It is pertinent to state herein that it was only by letter dated 30/4/2019. This was the letter which was issued by the medical college, Caste Medical College. It is pertinent to state herein that it was only by letter dated 30/4/2019 the ACR and APR particulars of the deponent and other faculty members were sought for on or before 2/5/2019 for scrutiny and submission to the government by 3rd of May 2019.
It's not a single case that I have submitted late. The entire faculty members of Tezpur Medical College was sought by this letter of 34/2019, and it was submitted on government on 3rd of May. Accordingly, on 1/5/2019, the deponent submitted her API particulars to TMCS. The process is once the API particulars are submitted by the deponent, it is the responsibility of the authority of TMCS to forward it to the concerned department. Prior to it, there was no official communication to the deponent to submit her API of that particular year to the authorities. Once again, on 31/7/2019, a letter was reissued by the DMA requesting for submission of API particulars of the deponent and other faculty member, who is the deponent submitted in the office of the DMA on 5/8/2019. Thereafter, again, a telephonic instruction from the office of the DME, the deponent resubmitted her API particulars on 1/11/2019. It is categorically stated here that the belated submission of the API of the deponent was never a hurdle for non-consideration of a promotion, as all the APIs of the concerns here were before the DPC, which is clearly reflected in the minutes and the statement. So nobody is disputing. I'm not disputing the dates of my learned friend. I'm not disputing the office memorandum, but there must be some lapses or negligence on my part. If the Tezpur medical authorities have devised a procedure to collect all the API particulars of all the faculty members, and then it's sent it to the
duty of the authority to request them to submit. It is their duty, my lord.
That is stressing,
my lord, as per the notification,
that
my
is
lord.
stressing too far. The submission I have made, he has also made it on the last occasion. We are just refreshing your lordship. On the last occasion, what I could get from my learned friend is that the government is not willing to give me this responsible promotion unless it is specifically done. That I could understand, because he has not addressed your lordship that government is going to. So your lordship will issue a mandamus to do it, madam.
If your lordship perusses annexure 1, page 4, page 4 of the affidavit, my lord, the eligibility criteria for promotion, my lord, what has been stipulated, my lord, in Roman 4, my lord, IPR for 2018. So it has been specifically mentioned. And IPR, my lord, it has the authority is not to invite the IPR of the individual from the concerned person, my lord. It is the duty of the officers to submit the IPR, my lord. It is not Annexure 1, page 4 of the affidavit, my lord. Down below, my lord. The committee considered the following criteria for promotion.
It will be running page 48, my lord.
Eligibility, service tenure, teaching experience as per MCI norms, requisite number of research publications, ACR in last 3 years, and IPR for 2018. So as per the notification, my lord, the petitioner did not submit the IPR in due time, my lord.
No, Bora, what this court is saying is, that is correct.
Yes.
This committee considered this service tenure, requisite number of research publications, whatever, ACR last 3 years, IPR for 2018. Then the findings of the DBC come to page 7.
Yes, my lord, I have seen it.
It says that would have been eligible for, but for non-submission of ACR.
Yes, my lord. Yes, my
IPR was there.
Yes.
API was there, because your lordship will see the running page 56 of the same affidavit.
My lord,
API, yes.
My note says, my lord, it is a recommendation, my lord. After the recommendation, the petitioner in fact approached the department that ACR, it is not the duty of the concerned officer to submit ACR, because if the ACR was not submitted in due time, if it was not within the before the DPC for consideration, it was not the fault of the petitioner. With that plea, the petitioner approached the department. So on thereafter, the department considered her case and found that even she is not eligible in terms of submission of IPR also, my lord. Therefore, my lord, because DPC, my lord, DPC only recommends, but appointing authority is the government, my lord. The deponent who has signed the affidavit, my lord. So that the deponent has categorically stated that, my lord, the IPR, because her case, it is also an additional ground. Because of non-submission of ACR in due time, or because if the ACR was not in front of the DPC in while the case was considered, that may be a different case, my lord. But after that, my lord, because on the basis of the recommendation, the appointing authority is the government, respondent number 1. Who has to appoint, my lord, make the appointment. So accordingly, the petitioner, my lord, approached the respondent authorities that because of the absence of ACR, if she is denied the promotion, it is not fair. Then, my lord, this fact has come to the knowledge. Because at the time of DPC, probably ACR was not there, so this they did not go to this aspect, my lord. But now, my lord, two things, my lord. First thing is that, my lord, if she is not eligible, if she cannot stand on her feet, my lord, she cannot challenge the promotion of others, my lord, as per the settled law, my lord. And secondly, my lord, even if, my lord, if your lordship finds that there is some mistake on the part of the DPC, my lord, what way your lordship may direct for convening a review DPC to consider a case of the petitioner, my lord, by considering her testimonials, my lord.
Hello, it is taking
Because,
us
my lord-
nowhere, your lordship. What we are repeating in the last occasion, it is taking us not here. Your lordship has understood what is the problem. Your lordship will issue a mandamus to comply with the direction.
You are for? And I am for the respondent number 5. Okay. Respondent number 5 has, my lord, submitted all the required documents, my lord, as sought for, my lord, by the Departmental Promotion Committee, my lord, in tandem with the office memorandum, my lord, that lordship has already paid. 1 minute, my lord. Who is that? Respondent number 5, is it 5 or 6 who submitted
Bhaskar Das is respondent number 5.
who submitted the IPR late?
6.
That is R6.
R6.
R6 in which petition? Here it's only R5.
My lord, no, your WPC number 5231.
My lord, yes, in the second petition, my lord. How about 6 and 7? Anybody agree? Six. Seven. Yeah, Babujani, what do you have anything to say?
He has already got the benefit, my lord.
Well, I have already got the benefit. But as per the gradation list, my lord, I am 1 point below the petitioner. Now here, my lord, my submission will be, my lord, the government has already laid down the parameters, my lord, that in the office memorandum, my lord, dated 5th of February 2014. I am not castigating the petitioner, my lord. I am just going by the record, what the record spills out, my lord. Now, this OM is, my lord, dated 5th of February 2014. On my part, whatever is required, I have submitted. And it is my categorical submission that as per this OM, my lord, the duty is casted on the officer concerned to, my lord, produce all the materials. It is not a case under the OM that the authorities at the first point of time will have to place a request to the officer concerned that, look, you have to place all the materials to the authorities, which in turn will be placed before the DPC. No, it is the other way around. That is one aspect of the rules, and this has exactly, my lord, been followed and adhered to, my lord, by the DPC, my lord, in the meeting. There, my lord, lordship will kindly come to page 4 of the affidavit, my lord. Down below, lordship is just now perused. My lord, the condition precedent, it is the eligibility condition. My lord, I will have to first of all fulfill the eligibility criteria to get into the room. That is the zone of consideration, whether I would come within the zone of consideration for being promoted. Now, to get into the zone of consideration, there is a door. And that door, my lord, provides for 4 conditions. Number 1, service tenure, teaching experience, that is not under dispute here. Number 2, requisite number of research publication, also not under dispute. ACR in last 3 years, my lord, that is not under dispute. Number 4, immovable property report for 2018, IPR, which admittedly, my lord, the petitioner has not submitted. In this regard, the petitioner's submission is that, my lord, she was not requested. The authorities in the Tezpur Medical College did not make a request or did not ask the petitioner to provide for all the details. No, in terms of this OM of 2014, because this OM of 2014 precedes, my lord, this DPC meeting of 2018.
Yes.
It is something like, my lord, that my matter is called, I am not present in the court, dismissed for default. I have to face the values.
My lord, I'll give a short reply.
You
My lord,
give letter 6.
Otherwise, my lord, it is not the case of petitioner, my lord, that the petitioner is pleading mala fide, my lord, in respect of any of the respondents out here.
I have more or less a similar submission.
You are Mr.
DM Nath. The petitioner who himself or herself does not fulfill the criteria.
Did you submit your IPR on time?
Unfortunately, my lord, as per report, it is not submitted.
No.
But things that, my lord, the petitioner who herself has not submitted the requisite criteria as per the OM dated OM of 2013. She cannot challenge my promotion here. That's not us.
She's not challenging your promotion. She's just praying for
Notional.
giving notional promotion.
That's a lot of the submission made by the state.
কিন্তু চেঞ্জ কৰিছো নে এনে চেঞ্জ কৰিছো আমি
I plead your lordship. My lord, I am on behalf of my lord respondent number 7, my lord. I have filed affidavit, my lord.
You are Mr.
I am Islam. I have filed affidavit, my lord. In WPC, my lord, 5231 of 2022, my lord.
Yes.
My lord, I advance the argument of my learned friend, my lord. In addition to that, my lord, the officer who do not submit APR would be denied vigilance clearance, my lord, and will not be considered for promotion, my lord. My lord, at the time of DPC, my lord, the petitioner did not submit APR, my lord. So at that time, my lord, she was not eligible. Moment she submitted, she became eligible, she was promoted, my lord, in the second time, my lord. And my lord, the OM dated, my lord, the date, my lord, 5 February 2014, my lord, is not challenged by the my lord petitioner, my lord. It is still in force, my lord.
OM dated
OM dated 5/2/2014, my lord. And except 3 of my lord affidavit filed by the my lord respondent number 1 in WPC 8/9 of 2019, my lord.
as with regard to the APR.
My lord.
Yeah.
মানে short
So, my
reply
lord, second time, my lord, she was promoted on the basis of this, my lord, this, my lord, office memorandum. So, moment she accepted the promotion, my lord, she cannot deny the, my lord, earlier prospect, my lord. This is my humble submission, my lord.
my lord we'll only recall my lord rules of procedures are always made to advance the cause of justice. It's to not to cause miscarriage of justice. You are trying to say that the APR was not before the DPC. Yes, you have an office memorandum, but if your lordship looks at page 56 of the affidavit filed by the respondent number 1 in WPC 8292 of 2019, my lord.
Yes.
My lord, as per the minutes of the DPC, the requirement was APR of 2018 and page 56 at 12. That is their own document which says that the APR was there. It is yes. If the APR was not before the DPC and in spite of that my name was not recommended, then the case would have been different. But it was before the DPC. So, my lord, it is always says that the rules of procedures are always the handmaid of justice. It is not the mistress. You can't extend the rule of procedure to such an extent to cause miscarriage to a person to a lady who is senior to you all. So your lordship has given an option. They did not want to comply. Your lordship will issue a mandamus. That's my humble submission before your lordship, my lord.
One thing, my lord, in my lord affidavit, my lord,
You have concluded. You have concluded. Any more?
No.
Okay, I'll just reserve the judgment.
Yes, well.
My lord, one thing I am not allowed to point out, my lord. My lord, page, my lord, 48, annexure 4 of my lord affidavit, my lord, filed by the respondent number 1. The criteria for promotion
4 criteria, all are independent criteria. my
That
lord.
I thought.
My lord, all are independent criteria. But she has to fulfill all the criteria, my lord. And my lord, regarding the my lord, the findings of the my lord, findings of the my lord body, that only ACR 4 year as per record, my lord, that may not be reflected, but she has to fulfill the my lord. She has to fulfill Roman 4 my lord of criteria, my lord. That is the my lord APR for 2018, my lord. This is my humble submission, my lord.
Well, it is taking us nowhere, my lord. What has been said is being repeated again and again
Only one submission.
in installment.
No, my lord, I missed it. I missed it, my lord, with all fairness. My lord, if my lord allows the repetition, assuming my lord, and my lord, the petitioner is already promoted from a particular date here. And at an earlier point of time, she was not promoted because of some reasons, my lord. From one point of time, she was promoted. Now, my lord, if she is promoted, if she is given notional benefits, my lord, as per the claim of the petitioner, now, my lord, that should not disturb the already promotional.
It is not
aspects,
going to disturb my
of the-
friends. Only mine,
Respondent
promotion and
5
seniority.
6, 5, 6, and 7. My lord, that is my respectful submission.
No, you have been promoted.
We have been, no, my lord, if the clock turns back, my lord, if she is seeking for retrospective promotion, then my lord, that gradation list will be disturbed.
It will change. It will
So that
change.
will not
Notionally,
change.
that has to change.
That will
That is why the discrimination has occurred.
That will change.
Yeah, that will change, Bala. That's the law, Bala. And this reviewed DPC is alien because subsequent DPC has.
By itself is not a, my lord.
Bala, we'll take up, we'll conclude
sir,
here. Your loss will.
Yes,
Maybe one more, let's to the stage about. But also heard Mr. DB Bora, then standing council health department.
Yes.
Governor Vassam. Mr. R. Barbajari, then a council for response number 5. Mr. DM Nath, then a council for response 6, and then M. Islam for hearing council. Yeah.
We are obliged, my lord.
And so obliged.
Operative portion of the order.
This is a contempt matter, my lord. There's some unfortunate teachers approached this honorable court because similar teachers, my lord, they got the nearby schools got the benefit in who are junior to the school. Notice issue. My lord, notices have been issued and they are yet to respond. It is service excuse. Huh?
She's appearing. Respondent.
My respondent has appeared, Mamta Hojai, but she is yet to file her reply.
My lord, in this matter, her case is placed in a state level committee, and a state level committee examined the matter and considered her case and send it to the government for approval. So, my lord, some time is required. It is
My lord, this school is,
awaiting under government, my lord.
my lord, your lordship will, my lord, this school where this order was passed, now it will be merged from with another school from 1st of August. This is in the same campus. Then I will be without a job if they don't comply this order immediately. Other teachers' appointment letters have already been issued, my lord. And this, because of the delay, my lord, I will be without any job from 1st.
As per my instruction, my lord, here, the matter was placed before the state level committee for consideration regarding the provincialization of the service of the petition. The state level committee examined the matter thoroughly and recommended the name of the petitioner for provincialization as per rules and procedures. And as per recommendation of the state level committee, necessary proposal has been submitted to the government via the office letter and so together with all other cases in a single lot.
My lord, they have
So, my
already.
lord, in this regard, if required, I will file the
What has happened in this
about
case?
this instruction, my lord. So now
No, you've recommended for provincialization, isn't it?
No.
Yes.
Can you speed up the?
Yes,
process?
provincial. And my case was not considered because my name should have gone as Archana Fukan. Instead of typographical error, it went as Archana Goswami. Government, court has also realized, government has also realized the mistake. They have to issue a consequential order correcting it from Archana Goswami to Archana Fukan. And if they don't do it by this end of this month, then from 1st of August, my lord, this school is now merging with another school. So I will be jobless, my lord, because in case of others, appointment orders has been issued, my lord.
There's some problem coming up.
My lord,
Let him
they
have an
not
instruction
implemented
on Monday, my lord.
They have not implemented the secretary here, my lord.
And this order is of 22/9/2021.
So now it is under the government level, my lord. So if the secretary party, he would have.
My lord, let him have the instructions. Let him, your lordship give an opportunity. Your lordship will fix it at Monday at 2 p.m. Let us have an instruction because this is the order of the court of 22/9/2021. They had enough time to comply with this order.
Chisti, you can apply your office.
Yes.
Get the order.
Yes,
out
yes,
by
yes.
Monday.
Yes, I'll pass it.
But we can know, let us know.
I'm furnishing the copy of the contempt petition to Mr. Sisti by today.
Assisted by Mr. H. Agarwal.
You
Mr.
Sharma.
U. Sharma, Learned Council for the response number one subjects that the state level committee has recommended the case of petitioner for provincialization. And the same has been given, sent down to the government for approval. Stuff. In that we have the matter, list the matter again on 31st July to enable Mr. U. Sharma to receive further instructions. In as much as this is control.
Development.
So are we arguing for disposal of this matter? Not a very long matter. Only the issue is whether the rejection of the cases of the present petitioners for appointment as Hindi teachers in primary schools is in conformity with the service rules, relevant service rules. That is the only issue.
Just a minute. I'll be back in 2 minutes.
(17) pursuant to which we applied for the post of Hindi teacher.
Page?
Page 26, annexure 1. Advertisement dated 30th March 2017. 2939 numbers of regular vacant posts were advertised in upper primary schools under the Directorate of Elementary Education, Assam. Lordship, that 2939, last but one line of the first paragraph of that advertisement. 2939 post.
Yes.
And the post of Hindi teacher qualification at page 29 of the advertisement. In
Yes.
29, the qualification part, Hindi teacher, graduate teacher from the UGC recognized university having Hindi as one of the subject and UP TET and 2-year diploma in elementary education or B.Ed or DLEd or B.Ed education. This was the qualification prescribed as per the advertisement. And they were selected also. The petitioners were selected.
Will the select list?
Yes, the select list at page 44, provisional select list. Page 44, and the names of the petitioners, they are reflected at page 45. 45 and 46, page 40. If your lordship first peruses page 45, the provisional select list. Serial number 13 and 14.
This is a petitioner number.
Petitioner number 1, petitioner number 2, petitioner number 2, petitioner number 2, serial number 14. And page 46 is the petitioner number 3, serial number 3. Petitioner number 3.
This is Dhemaji, your
Yes,
Nagaon.
Nagaon and Dhemaji, yes, yes, Lordship. 2 for Nagaon and 1 Dhemaji, yes.
Yeah, Hindi teachers.
Hindi teachers, applied for the post of Hindi teachers. Lordship will kindly peruse the document at page 51. They were by notice dated 13 July 2017. They were requested to attend the office of the Director of Elementary Education for re-verification of their original documents.
No, these are with regard to candidates who are kept withheld, but you are not withheld.
We were withheld. We were not appointed. Even though our names appeared in the provisional select list, we were not appointed. After that, we came to know that our names have been withheld, and pursuant to that, the reason for withheld was we were our documents were being subjected to re-verification. That was the reason given. But even after the re-verification, our appointments did not come. So we were constrained to approach the Honorable High Court. The first round of litigation therein, the order that was passed on 7/2/2018 at page 53. Direction was issued to complete the re-verification within a specific period. If your Lordship peruses the order dated 7/2/2018, passed in WPC number 6133 of 2017, page 53. If I may read the paragraph 3 and 4, the operative part of this order. As the selection of the petitioners were withheld, they were not so appointed, although people above and below the petitioners in the respective select lists were appointed. As the reason stated in a notice for not appointing the petitioners is that their selections were kept withheld for some re-verification to be done on the given date indicated in the notice, this court is of the view that the appointment of the petitioners cannot be kept in abeyance for all time to come. As the notice indicates the date and time for re-verification, it is expected that the re-verification had been completed in the meantime. Even if the required re-verification has not been completed, the authorities are not required to complete the re-verification within a specified time period. Upon the re-verification, if the testimonials of the petitioners were found to be in order, the earlier selection shall be brought to its logical end. If the same are not found in order, appropriate reasoned order be passed and the petitioners be intimated about the same. The aforesaid process to complete the re-verification as agreed by the parties be completed within a period of 2.5 months. Despite the order of the Honorable Court, as in all cases, this was not complied. So we approached by way of a contempt proceedings. And in the contempt proceedings, an affidavit was filed on behalf of the director stating that we were not eligible to be appointed as we were not qualified as in terms of the rules. At page 55 is the affidavit filed by the Director of Elementary Education in the contempt proceedings, contempt case number 326 of 2018. The relevant portion wherein the state at page 57, paragraph 6 of the affidavit. The deponent makes a state that the grievance of the petitioners were verified, and after verification, it was detected that Mitali Bora, that is the petitioner number 1, has acquired degree without having Hindi as one of the subjects. In respect of so-and-so, that is the petitioner number 2, her percentage is even below 45% being OBC candidate, and the third petitioner has acquired degree without Hindi as one of the subjects. So the reasons cited are, so far as as concerned the petitioner number 1 and 3, they do not have Hindi as one of the subject in graduation. And so far as the petitioner number 2 is concerned, her percentage is below 45% in the graduation. That is what has been submitted, stated in the affidavit. And this is what is being challenged in the present writ petition, as it is the reasons which has been cited is not in conformity with the rules, because the rules does not say that for being eligible for being appointed as a teacher in an primary school, one has to have, even if in the relevant subject, one has to have Hindi as one of the subject. And secondly, the percentage of a specific percentage which has been quoted of 45, even that is not there. So, and they are qualified as per the rules, that is the Assam Elementary Education Provincialized Service Rules. If I may take your lordship to the relevant rules, as this is the only thing which you are challenging here. Assam Elementary Education Provincialized Service Rules, 1977. Assam Elementary Education Provincialized Rules, 1977, lordship at page 293 of that book. 293.
Yes.
293. The qualification which has been prescribed, the rule 3, continuation, rule 3, method of recruitment. Provision with regard to recruitment is contained in rule 3. And the relevant provision with regard to qualification, rule 3, sub-rule 1, subsection rule 3A, at page 296, qualification, 296. The minimum qualification of a person to be eligible for appointment as a teacher in elementary school shall be as per notification issued by the state government from time to time in conformity with the NCTE norms. These qualifications shall be applicable to an category of elementary schools. In case of any relaxation required in respect of any qualification as prescribed by the NCTE from time to time, the state government shall take up the matter with the Government of India for such relaxations. This is the only provision which is there in the rules with regard to qualification, does not prescribe any specific qualification. It only has a reference to the notification that may be issued by the state government from time to time. And the relevant notification which is holding the field.
What is the NCT norm?
Yes, we have enclosed that. We have enclosed it. The notification which has been issued at page 60 of our petition. Page 60. This is the notification which will govern the selection and appointment of teachers in terms of that advertisement. NCT notification dated 23rd August 2010, which has been issued in exercise of powers conferred under Section 23 of the RTE Act, Right of Children to Free and Compulsory Education Act. And the relevant portion with regard to upper primary schools is in the next page 61, serial number 2. Roman 2, classes 6 to 8. For Lordship peruses, the qualification I'll read out. Necessary qualifications: BA, BSc, and 2-year diploma in elementary education by whatever name known, or BA, BSc with at least 50% marks and 1-year bachelor in education. Then again, there is an or BA, BSc with at least 45% and 1-year bachelor in B.Ed in accordance with NCT regulations issued from time to time in this regard, or senior secondary or its equivalent, or at least 50% marks and 4-year bachelor in elementary education, or senior secondary or its equivalent with at least 50% marks and 4-year BA, BSc, B.Ed, or BA, BSc, B.Ed. And the next alternative qualification at next page, BA, BSc with at least 50% marks and 1-year B.Ed special education. So any of the qualification which is cited here, that if we are covered, if we have any of the qualifications which is stated here, we are eligible for appointment. So the present petitioners, they are all graduates. They are all they all have DLED degrees. Of course, at that point of time when the advertisement was issued, they were pursuing the DLED course. But even with regard to that, there is a notification of the central government that is followed by them, by the state government, that for the purpose of the particular advertisement, the DLED, the acquiring of DLED degree was relaxed at that point of time. So even they are not, that is why the director in the affidavit, which I have just pointed out, they have not stated anything with regard to the DLED degree. Only clause is that, only objection is that we do not have two of the petitioners do not have Hindi as one of the subjects in the graduation degree, and one of the petitioners has less than 45% in graduation. That is what they say. But but here, if your lordship peruses, one of the qualifications which is referred to in the NCT notification is one can also possess senior secondary or its equivalent with at least 50% marks and a 4-year BA, BSc and a graduation degree, along with a graduation degree. We know, even without that, we all have the graduation degree, but only thing which they are on the possession of that Hindi as one of the subjects. We do not have Hindi as one of the subjects in our graduation degree, but we have the Praveen degree. Even if they come with an objection that Praveen degree is not acceptable, they are required to have Hindi as one of the subjects. When the rules do not say so, it cannot be insisted on. And even the NCT rules say that in accordance with the NCT notification adopted by the state government from issued from time to time, that will guide the.
Do you have that?
Yes. Yes. Our qualifications are there. Okay. We'll select this one. 32. Lordship, all.
More precisely, my lord, the advertisement contained this clause, my lord, the eligibility criteria.
Advertisement is there.
Yes. They participated in the advertisement without any challenge.
No, that cannot
The
be.
advertisement is not.
They're not challenging the advertisement.
They are not challenging the advertisement.
What they are saying is that in terms of advertisement, they have participated.
Yes.
Having Hindi is one of the subjects.
My lord. And the advertisement is very clear, my lord, page 29. The qualification that Hindi has to be one of the subject, my lord, in the graduation.
Lordship, they cannot insist that since the advertisement prescribes that qualification and we participated in the advertisement, we have to challenge the clause in the advertisement in order to bring home the to satisfy that that cannot be insisted on. That is not so, because the Honorable Apex Court in several decisions has clearly laid down when the advertisement is not inconsistent with the rules, then the rules will hold, not the advertisement. And just because they have issued a clause in the advertisement which is not inconsistent with the rules, they cannot insist that just because the advertisement has prescribed that particular qualification, particular criteria, and without challenging the advertisement, without challenging the criteria, we have participated. Now we cannot say that just because the rules does not say. That is not so. I can place decisions on that point. We have decisions also on that point, that when the advertisement is inconsistent with the rules, then the rules will hold. Recent decision.
But Borgohan, Kaushik, what do you say?
Well, I'll have to file an affidavit.
That's what I'm saying.
Yes. Because.
But why are you delaying so long?
I'll do it within 10 days.
Lordship, in fact, when the matter came up on 17/7, Lordship, they accepted that they will not be filing any affidavit. They'll be relying on this affidavit. Mr. Majumdar was there. On my the submission which I had made.
Ground of rejection, my lord, we can rely on this affidavit. But with regard to the challenge made in this repetition, my lord, without challenging the advertisement, well, I would like to hide my.
No, we are challenging all along. That is my pleadings. That is my pleadings.
17?
Yes. 17-7, when this matter came up, I prayed that we'll be relying on these as it is. We are challenging the grounds as stated in the affidavit.
Where's Majumdar? Majumdar, you are appearing now?
My lord, I'm appearing. Mr. Mojumdar, he is in legs, my lord, in some.
No, but in any case, who's appearing?
But I'll be appearing. My lord. Your lordship grants me 10 days time, my lord, I'll file my affidavit.
As a last chance.
Last time, I'll file my affidavit. Lordship can take
Lordship,
up.
the affidavit does not come, this will be taken up because.
Yes, yes.
That's why I'm.
Yes, my lord will indicate that.
Because these are everything.
Standing council, elementary.
My lord.
Education department is allowed 10 days time as last chance to file counter. If no counter is filed by the next reasonable date.
Division
case shall be taken up on the basis of the evidence available. It's down. Give a date of 10 days. 14th August.
My lord.
Lordship, can it be on a non-miscellaneous day and a
I've been
hearing day?
just given an instruction, my lord.
17.
On 29/7, these petitioners have been called for a verification.
On 29/7.
29/7 at 2
At
p.m.
least 29/7.
Probably that will have a relevance, my lord.
For a verification.
Verification.
Is it some sort of a process for appointment? In any case, you're submitting on instructions.
Pursuant to the advertisement which they have participated, my lord. Now they have been called for a verification on 29/7 at 2 p.m. at the office of the deputy director, my lord.
So this is pursuant to the, my lord, this will have a relevance, my lord. It will be after 29/7. I'll get the outcome of.
Yes,
the
after 29/7 only, after
Yes.
29/7. If this is a if this is a positive development, then probably they need to, yes.
Alright.
In any case, 17 August, Lordship, 17 August.
17.
Yes, 17.
Thank you.
Maybe. This is like for regular for salary. I was appointed.
Coming for orders.
It is my instance, Miller.
Huh?
It is my instance, Miller. It was notice issued on the 20th of March, Miller. Then we have taken steps properly. And there is no private respondent, only government is party, Miller. And I approach this honorable court, Miller. And the honorable court.
All our official respondents.
All.
No problem.
No problem.
Then
I was appointed. I am working till date, Miller, and I was selected. But my salary was not given. So I approved with it. They only could pass order, Miller, page 46, page 46. Paragraph 8.
yes, Sukan.
No, sometime maybe allowed, and she has accommodated now, as a tutor, and she's claiming for the last area salaries,
That's why.
so sometime maybe allowed.
Okay.
I work for
Earlier she was
regular, Miller, but I have been given Miller tutor post.
She was
Then why is
appointed
it coming for orders? He should come in the admission column.
But it is my instance, Miller. That is, yes, you lost it right, Miller. I made a mention that it is come, Miller. So anyway, it may come on admission then again. Miller.
Go to your worship, then the council. MS Sukan, then the standing council. Elementary education is allowed 2 weeks time.
3 weeks.
2 weeks time.
Admission.
Is the matter after 2 weeks in the admission column.
In more 20th Miller, 20, yes, 21st Miller, 21st August.
All right, Master.
Tomorrow, no? Tomorrow. Today I'm not feeling well.
Today not required, Lordship, tomorrow.
Item 22, ordered.
Lord, if your Lordship, I file a short affidavit, if Lordship go through that affidavit in the IA, my Lord, on 24, just to bring to your Lordship notice the difficulties that we are facing. Lordship got it, my Lord, flag C in the IA. My Lord, this is, Lordship got it, my Lord. Lordship will kindly come to page 99. This is the notice given to us, my Lord, by to the school for disconnection, notice of disconnection of electricity. And the next page, page 100, my Lord, 1,03,000 has been, my Lord, they said they were to deposit or will disconnect. They came yesterday, my Lord, to disconnect. But on a request made by the headmistress, says the matter is fixed today. Because, my Lord, as I submitted before Lordship, said, my Lord, we are not going into dispute between the parties. Lordship agreed on principle, my Lord, that let the pay and allowances, other urgent expenses may be made by the headmistress of the school. My Lord, keep an account of it, submit before Lordship, and the checks may be signed by the inspector of school, the independent, my Lord, neither of us. That will for the time being, my Lord. And an implement petition is filed by the Guardian Society that is not on record. A copy is served on me again.
That is filing number is with me, but not on record. Let it matter.
No, that is all right, my Lord. Lordship will to go into it. I'll file an objection to this. That is the matter, and I'll file my counter in my IA that I filed when praying for a my Lord modification. Lordship need not dispose of that IA also. Lordship will kindly allow the teachers, the peons, chokidars to draw. Since last 4 months, they are not getting the salaries. This is number one. Urgent expenses could not be made, my Lord, because of the confusion arising that because of the Lordship is aware of that. My Lord, my submission is very limited, my Lord. This will not cause prejudice to any of the parties, my Lord. Let the teachers draw their salary. Let the checks and bank my Lord, drafts and others may be signed by an independent, neither of us, my Lord, because who will sign is a dispute. And President is also not there. That's why, my Lord, the Lordship will kindly pass an order to this today. My Lord, the Lordship indicated yesterday because my learned friend wanted to obtain instruction on that. And the government council also was not there. I mean, Lordship will only very limited prayer, my Lord. Innocuous prayer, my Lord. Innocuous. Let us draw our salary and all. That's it.
I obtained instructions, my Lord. This, my Lord, I cannot concede. This prayer, although it is not there in the petition, the interlocutory application. And besides that, my Lord, this will create further problems because this is not this is unaudited finance, my Lord. Since 2014, my Lord, it has not been audited. Huge amount is lying there. There is every possibility of misappropriation. And therefore, my Lord, I cannot concede this.
My Lord,
this is also not
making expenses towards electricity will cause misappropriation. I'll say it. I'll submit before Lordship the expenses that I make before Lordship by filing an affidavit. Each and every transaction. This is salary. How audit problem, Lord?
My Lord,
salary. There is no question of audit here because private institution.
My Lord, let them comply with the interim order. Every problem will be sorted out. There is an interim order.
What interim is that?
Interim order is that, my Lord, that is suspend the operation of the resolution by which this body is functioning, my Lord. That has already been declared by your Lordship that this is illegal. And this resolution was, my Lord, stayed. Let them comply with this interim order. All this problem will be sorted out.
Interim order?
My Lord, it is in the in their miscellaneous application, my Lord, it is at page 17.
Page 17, the misapplication.
Of their misapplication.
IA.
I 1131.
Page 1707.
17. This is the operative portion.
No, 17 is
running page 40.
Running page to different.
Page
Running page, my lord, page 40.
40.
Yes, sir, lordship. There is no interim on this.
Suspension of the minutes.
Minutes doesn't automatically restore. There is Supreme Court decision. And what the prayer is, my lord, kindly see one paragraph of the Supreme Court decision, my lord, the copy. Just short paragraph by which, my lord, lordship will go through it. My lord.
My lord, what I
Para 12, lordship for the just for a while. Para 12.
Let this matter be heard finally.
Yes,
instead of
but
making
then
all-
we must survive, my lord. Para 12, lordship, just for a while. Para 12, small paragraph. This is Chamundi's number of decisions are there. Para 12 at page 780, lordship got it. My lord, as has been pointed out by so-and-so in Chamundi, while considering the effect of an interim order staying operation of the order under challenge, a distinction has to be made between quashing of an order and stay of an order. Quashing of an order results in restoration of the position as stood on the date of passing of the order, which has been quashed. The stay of operation of the order does not, however, lead to such a result. It only means that the order which has been stayed would not be operated from the date of passing of the stay order, and it does not mean that the said order has been wiped out from existence. So that's the this is law. And lordship will kindly see, have a look at their prayer, read petition prayer, lordship for a while. Read petition prayer, my lord will kindly see.
Mr. Roy, if we are going to have a disposal of this writ petition, let us have a disposal.
Disposal, but why is the salaries? But because 4 months they are not getting.
You are praying for impletement.
Yes, lordship, that is not, I have filed it on 18/7, lordship, that is not on record, lordship. Let the matter come up along with that, lordship, my implicit petition, lordship.
Tomorrow.
Sir,
Let it
But
come
no,
up.
I'll have to file objection. It will not be disposed of because various incorrect facts have been placed in the application. That it will not be disposed.
Whatever it is, let it come up.
So lordship will take it up then on Tuesday next, my lord. Tuesday next.
DK Roy and the senior counsel. Assisted by Mr.
SK Chakravarti.
SK Chakravarti, London Council. Applicants.
I am for the applicants in the eye. My lord, I don't understand, my lord, this objection. Drawing salary by the teachers.
Also heard MSP Chakravarti, London Council for the sole opposite party of the petitioner. MS
P. Bhattacharya.
P. Bhattacharya, London Council supplement. That she has filed in IA in connection with the present case for implement stop. Accordingly, this case, the IA on when do you want? Tuesday.
Tuesday next, my lord. Monday it will not be because the list will be long, my lord. Monday. Tuesday is a my lord, hearing day.
1/8. First of all.
First.
Let's see what happens on that day.
My lord, I just made an innocuous prayer, my lord. I don't understand. Anyway, my lord, let it be.
Chakravarti, you can have a think. You can think about it.
My lord.
In the
Now,
interest of
there is a complete
school.
School only. And this is a purely private school, my lord.
Complete my lord, mistrust. Nobody is trusting anybody. Now their guardians are thinking.
Then we'll get the inspector of schools to do it.
That's why that is the innocuous prayer, my lord.
Think about it.
My lord, they are saying that inspector of school handling this finance is all right. But since 2014 is not audited. There will be
So
again.
from the date the order is passed, that the report and all will be kept properly by the inspectors. Think about it.
This audit, there is no pleading as such, my lord.
My lord, there is no pleading that they want this order, my lord.
Why, my lord? This is
not
a-
there in their
then
petition
dispose
also.
of the way IA.
How can I
Dispose
concede,
IA,
my lord?
this
This
is-
is not there in the petition.
All right.
Very unreasonable, my lord. Anyway, my lord, leave it to your lord.
23.
Why is it coming forward?
My lord, that is admission, medical admission, my lord. Last time it came before lordship, my lord. They belong to Julha community. And this student, he passed that, my lord, examination. Now he is to appear in the counseling, my lord. Now in the counseling, he is to appear, my lord, he is to submit a certificate of non-creamy layer, my lord.
Now,
Non-creamy layer certificate he used to file. Now, once he filed the online petition, my lord, it does not accept it, my lord. Now it came to know, my lord, that this Julha community has been removed from that list. So our prayer is, my lord, that you will kindly see my certificate, my lord, page 18, page 18. Fact that I belong to that community, my lord, that cannot be taken away by notification.
page,
Page 18, my lord. Caste certificate, your lordship.
yeah, caste certificate.
Yes.
Abdul,
Abdul, there is a petition of your lordship. And so T. Kashipur, ex-T garden, there's people on. Belongs to Doyagaon under so and so subdivision in the district of Kachar, belongs to Jalha, ex-T garden, Lebaga, my lord, caste community. So this certificate was issued, my lord, on 4/1/20. Then thereafter, your lordship will find another certificate. Last two page, my lord. Last page 30, TN 34. Your lordship will find middle, my lord. This is to certify that Abdul Razak Siddiqui, son of so and so district Kachar in the Assam, belongs to OBC Julha. Your lordship got it, my lord. Community. The next page, your lordship will page 34, same. Similar, my lord, MOBC. OBC, MOBC, almost same, my lord, the same category. Now what happened, my lord? I already, my lord, I passed higher secondary examination. I come within the zone of that quota. I may appear for counseling, my lord. In the counseling, it depends, admission depends on counseling, my lord. According to marks, my lord. Now, once I am to apply online, because offline certificate is not available. I went to the deputy commissioner office, it is not available, my lord. Online, when I applied, my lord, my application, my lord, when I give the Kachar district, it does not accept it, my lord.
why?
Because now we came to know that this Kachar district has been excluded. All the tea garden, XT, Lebagas have been excluded from that year, my lord, by a notification.
Which notification?
That notification, my lord, they have produced subsequently, my lord. I think it is there in the file, my lord. And my certificate is issued, my lord, page 34. It was issued on 18/7/22, valid for 1 year. 1 year means, my lord, 17/7/23, this month.
So that has expired.
Now expired, my lord, after filing of the case, my lord. But certificate, my lord, my caste cannot go, my lord. I belong to a particular community, particular caste, my lord, that cannot go, my lord.
What is this? What is the implication of this?
And that, notification lordship.
Oh,
Notification lordship, it says that Jolha community,
Has been
they
removed.
enlisted some district.
of some particular districts in
Yes.
Assam has been listed as OBC. Is
Yes,
it?
lordship. Yes, yes.
OBC as Assam and removed the community from the list of tea
MOBC.
garden and ex-tea garden tribes.
Under MOBC.
So I'm not very clear on this issue. You'll have to explain, Gogoi, you can try next.
Here.
I also could not.
Social Justice and Empowered Department. Specifying that, my lord, Jola community will now be considered as
OBC.
OBC.
who are resident of this particular
District.
So you are from
Kasar
this
is not a.
district.
Yes.
Yes.
You are from
My district, Kachar,
Kasar is not.
it
there.
is not there.
Enlisted here.
So, my lord, if the petitioner is aggrieved, my lord, then he will have to challenge this.
This one.
No, that is another
Because
aspect.
this is applicable to all entire state now. my lord. And the deputy
No,
commissioner.
no, 1
will
minute.
Not issue any certificate.
Here there are some districts.
Yeah,
Is Jola.
yes.
So he belongs to the Kachar district, correct? And he has been given a caste certificate also
Yes.
to that effect.
That's
Now, what happens with this notification?
my lord, this after this notification, that caste certificate will not have any force, my lord.
More particularly, when my lord in medical admission, they will have to have a counter signature in a separate form from the deputy commissioner or the additional deputy commissioner who has issued the caste certificate. Now this
You also in this matter.
Third will be the main authority will really issue this.
Another councillor.
Give a clear explanation on this one.
Another RM does the same. RM does.
Page 27, just it will make it more clear, my lord. Page 27.
No, that absolutely. This notification of 19th September 2022 says that the Jolha community, right, of some particular districts are listed as OBC of Assam
Yes, my lord.
and removed from the community from the list of tea garden and ex-tea garden tribes.
Yes, my lord.
What does this mean?
It means that, my lord, only particular this listed districts, my lord, the inhabitants of Golaghat, Jorhat, Sibsagar, Vishwanath, Tinsukia, Saraido, Dibrugarh, Lakhimpur, Sonitpur, and Nagaon, a separate entry in serial number 32 of the list. So, my lord, any person belonging to other than these districts will not be in the list of Jola. So, this Barak Valley, my lord, the petitioner is from Kachar district. So, Kachar district, we do not have, that has been withdrawn by this notification. And this notification is under challenge now in a separate, I think there is a PIL also. My lord, the thing is that so long this notification is, my lord, standing, they will not get the benefit of this Jola community. This will come in between. This notification is enforced, my lord.
See, Jola community is in all districts, isn't it?
My lord, page 27, it will make clear. my
One
lord.
minute, yeah. Jola community is in all districts.
Yes, my lord.
Now, this particular districts,
yes,
Jola community has been removed from the T and X-T garden tribes.
Yes, ma'am.
And put in the OBC list.
Yes.
What happens to the Jola community of the other districts which are not stated in this notification?
Yes.
They continue to be X-T garden, isn't it? Because certificate has already been issued to that effect. They still continue.
They have been removed, my lord, from Kachar district.
Name is not there.
Name is not there now. They will be not there in the list.
Oh, no. According to my understanding,
my lord,
the Jola community of this particular districts,
my lord,
in the notification,
my lord,
they have been removed from the ex-tea garden and tea garden tribes.
Yes, my lord.
And listed as serial number 32 in the list of OBC
Yes, my
of
lord.
Assam. That is clear.
Yes.
Now the Jola community, apart from these districts,
Hmm.
who are inhabited in other different districts also, like Kacha, where the petition is. He has been given a certificate.
That has been removed, my lord.
How?
That is what, if you read, my lord, in the last part, if you read separate entry at serial number 32 of the list of OBC of Assam and remove the community from the list of communities of tea garden and ex-tea garden tribes of Assam under MOBC at serial number 1.
Under serial number 81.
This is serial 81.
The language is not very clear.
That's why we are.
That has been removed, my lord.
Let us see your page 27.
Yeah, page 27, your lost hands. Page 27. Your loss will find E, my lord, E. Children of tea garden, ex-tea garden, community tribes included so and so. Then right side, 24 seats. Your loss will find very, very important. Out of seats reserved for OBC, MOBC, Brahmaputra Valley, 18 seats. Barak Valley, 6 seats. Your lordship got in mind. So they have allotted the seat, Brahmaputra Valley, 18 seats and 6 seats. This Barak Valley now, Kachar district included in this Barak Valley. So they, according to them, this is excluded. This 6 seats. Now my question is, my lord, I am having a caste certificate. Whether by a piece of paper, my caste will be taken away. Fact is that I belong to Julha community. Can it be taken away, my lord? My only prayer is I am maybe allowed to in the counseling. That subsequently, whatever may come, will come, my lord.
Without
Only I am to appear in the counseling, my lord, which is going on.
unless he has a certificate, my lord, he cannot.
He has a certificate. This is what is troubling this court. I mean, maybe I have not got the proper perspective of what they're trying to
My lord.
project. But so far as that notification is concerned,
My lord.
it says the Jolha community of this particular districts, they have been removed. Let us read it like that. They have been removed from the T and XT curtain drives and enlisted as serial number 32 of all VC Assam.
My lord.
Only those districts.
No.
Only those districts.
My lord.
Yes, yes,
The remaining districts,
that removed from the community. That will cover that line.
And remove the community from list of communities of T garden and XT garden
That will cover.
under the list of MOBC, my lord.
It will include the other district.
how can you differentiate the Jolas of one particular district to another district?
My lord, this notification has to be challenged without.
No, that is different thing, but let us understand this notification.
Gulagad, Jurahat, Chitkagar, Biswanath, Tinsukia, Toledo, Dibudo, Lakshmi. Entity is from the 32 in the rest of VC Assam. And they remove the community from the list. Who list some of the Buddha no festival on the canals.
আছে কিন্তু নাম শো করে না অফিসার করে না থাকে
My lord, may we have a look at the caste certificate for a moment. At page
Yep,
18 of
yep,
the report.
Yep.
Page 18 of the report.
Lordship certificate so and so, Abdul Razak Siddiq, son of so and so, mother so and so, village, town, T state, Kasipur T state, PO Nilam Dayapur, police station so and so, subdivision so and so, in the district of Kasar, Assam belongs to Jola, ex tea garden laborer. Caste. Now, my lord, this particular certificate has been issued from Kasar on 4/1/2020. This notification came into force in 2022. Moment this particular notification has come into force, this particular certificate will not be applicable now. Because today, if any candidate, say he has passed out for any educational purpose, he goes for a certificate seeking that he belongs to Dola community, and he will be, he is entitled for this caste certificate that the authorities will now, they cannot issue this. It was prior to that. And my lord, whatever is the present status, we will be following in the counseling, my lord. This 22 notification as on date is holding the field. So at the time of counseling, we'll have to, my lord, go by this particular notification. That's why, my lord, the provision is there that, my lord, whatever is certificate has been furnished to us, it will additionally have to be, my lord, countersigned in a separate form by the Deputy Commissioner. That's why, my lord. Now in 2020, if it has been issued, now 2022, my lord, the 23, my lord, the Deputy Commissioner will not give the counter.
Page 34, my lord.
That's the difficulty the petitioner is probably facing. Because without that form, she cannot have the admission.
Page 34.
He can, my lord, otherwise participate as a general candidate. There is no bar to that. But, my lord, he cannot, my lord, claim reservation under this particular category.
Neither under OBC or MOBC.
Yes. Because tea garden part, Lordship may see down below of the notification, it has been now deleted. And remove the community from the list of communities of tea garden and ex-tea garden tribes of Lordship. Earlier at serial number 181, Zola community was considered as, my lord, MOBC. Lordship will see the last name. It will be more clear of the notification of 2022. Last second line, may I read, my lord? And remove the community from the list of communities of tea garden and ex-tea garden tribes of Assam under MOBC at serial number 181.
Then
Now
what
this
about-
particular Zola community has been inserted as serial number 34 in the list of OBC.
What about page 33?
33.
34
also, madam.
34 is MOBC.
Yes. 33. OBC.
Page 33 is OBC. How can you get so many certificates?
Yes, then again.
Year wise, my lord. because-
1 year you get MOBC, 1 year you get
No,
OBC,
but year wise,
1 year you get Jola.
I appeared, my lord. 3 times I appeared before that examination, my lord. I could not. This time relaxation was made. I again qualified in the written for sitting in
No,
the
no, no,
council.
I'm not talking about
So
that.
every year, my lord, I collected
I'm
certificate.
talking about your certificate, MOBC, OBC, and Caste.
My lord,
This Jola. XT garden. Three certificates you have got. You're supposed to have only 1 certificate.
Yes, sir.
but the year wise, my lord, now they have issued, my lord.
My lord, nowhere in the certificate.
student
it says
con- my
15.
student
It
asked
has
for
been
certificate.
mentioned that it will be valid for 1 year.
Hmm?
Had it been a case that, my lord, it is valid
No,
for 1
even if
year.
it is valid for 1 year,
No, no.
after the expiry of 1 year, he can still apply.
No, I'm not saying that, my lord. Had it been mentioned that it will be applicable for 1 year, then he is bound to apply. Here, nothing has been stated. Once he has got the certificate, it is there, my lord.
I don't know. No, it is valid for 1 year. It is
Yes,
there.
yes, it is there, madam.
No, in page 18.
No, page 33, 34.
No, 18, my lord.
18
Page
is the
18,
general
birth
one.
certificate.
This is for permanent certificate.
And yes, this is non-familiar.
18 is without any limit, my lord.
This is non-familiar.
Not familiar with
That
one
is
year.
with regard to the income, my lord.
Yes.
Income of the parents.
Income of the parents, familiar, non-familiar. He is a non-familiar certificate, so that is valid for 1 year. If my parents' income goes up, I'll be out of this, my lord, children become this familiar.
No, creamilated, non-creamilated, that's different.
My lord.
What I'm asking, one question is, in 2021, he gets an OBC.
No, it's my lord, page 18, it is OBC or slash MOBC.
Come to
Same
page,
certificate.
come to page 33.
Yes, my lord. 33. It is dated 21. Acha, here it is OBC.
Here it is, come to page 34.
Yes. But the main certificate will be, my lord, page 18. This is the caste certificate. Non-familiar is, my lord. Subsequent to this certificate, they will issue a non-familiar certificate. That is why it is valid for 1 year. Now here, my lord, yes, how it is OBC and another it is MOBC. That
is the question I'm asking.
Yes.
If you have OBC, you should continue getting OBC.
Well,
considering your financial condition.
According to that.
How you have got OBC in 21, in 2022, you got MOBC.
By the same authority, my lord. Deputy Commissioner Kacha.
They have issued one.
This is the issue. You'll have to consider all this and file your reply.
No.
Reply long back, they are gonna order to file a reply, my lord. That was also not given. my lord. List is also not composed.
Lordship, may kindly fix the matter Monday on Monday.
Monday also, they will come with the same thing, or are you coming with something new?
Lordship, that instruction I have placed.
There's no point fixing cases if you come with nothing new. This certificate was submitted the other day.
Basically, his case is that Deputy Commissioner is in the system.
In terms
Yes,
of
sir.
this notification,
Lordship.
now the Jola community of Kachar district does not belong to the non-creamy layer, isn't it?
So not OBC slash MOBC. They do not belong to OBC or MOBC.
You know, OBC or
So
If that
the
clarification
question
is
of issuing the non-creamy layer now it doesn't apply because, my lord, one before that they will have to be a OBC certificate holder or MOBC certificate holder. Only then thereafter they can showing the income they can have a non-creamy layer certificate.
Last thing is they have to have a OBC or MOBC certificate, my lord. Then only.
Yes, both.
No, my lord, because of this notification, they are.
This was prior to September 2020. No, so you will see the dates, my lord. Prior to September 2022, she has got two. But now, my lord, after September 2022, the situation has changed. Jola is now, my lord, not a MOBC or OBC in Kasar district after this notification. That's why the system is not
Accepting, Lordship.
Otherwise, my lord, OBC and MOBC, it is always slash. Both are considered as one. Seats are reserved as one in the medical admission. There is no separate for OBC, no separate for MOBC. OBC and MOBC is considered as one category. At the time of counseling, at least at the time of counseling.
And his payer is for issuance of non-familiar certificate.
Yes.
His application not accepted in the system. In our parawise comments, Lordship, we have stated that as this community is not enlisted, Lordship, column is not there. So
you have to come clear with that. No?
No, Lordship, that is in the parawise comments.
By filing an affidavit, you have to
Lordship.
so that petitioner can rebut your affidavit. Give them a chance. They are not coming up with the affidavit. This is the problem. And my time is going on. Already counseling started.
I already sent it for vetting, Lordship. Can it be on Monday?
If you want Monday, I can do it on Monday.
No, that is if they come up with the affidavit, my lord.
Subject to.
Only in the meantime, my counseling already started. It may. My learned friend is saying, my lord.
Yes, on 25th it has started, but without this certificate, my lord, we are helpless.
No, that is there, but once if it is exhausted, my lord, suppose if I come within the.
I repeat again, my lord, even if you wait for the affidavit from the deputy commissioner, the situation remains the same. There is a notification admittedly, my lord, as on date. Without there being a challenge of passing of the notification, the Jola community in
Any interim order has been passed in the PIL or whatever it is.
Yes, they're saying, my lord, we did not find it.
It's not related to MBBS, my lord.
Nobody can say.
No, it's related to challenge to this notification. Isn't
Yes,
it?
that's why I'm saying, my lord. Not.
We have never, we checked it, my lord, it was not found. If that is there, let them say, my lord.
In that case,
We
my
did
lord,
not
both
get
the writ petition can be clubbed together in the final, it can be harder.
No, if it is a PIL.
PIL, then it will go to the division.
Number আছে নাকি?
Only thing, my lord, name of RM Das may be reflected, my lord, he's just standing.
RM Das?
Yes.
Who is he?
Standing Council for Social Justice and Empowerment Department.
What?
Social justice.
Respondent number 3, my lord, in the writ.
My lord.
More comfortable.
Okay, social. The government though. Huh?
No, there is a separate standing council for this department.
Third, Mr. H.R. Chowdhury, Senior Counsel, assisted by Mr.
AHMR Chaudhary.
A.H.M.R. Chowdhury, Learned Counsel for the Office. Also heard Mr. B. Gogoi, Learned Standing Counsel.
Among Health Department.
Health Department, Mr. R. Dhar, Learned Standing Counsel, Tribal Department, Tribal Affairs Department.
Not a party.
Oh, you are not appearing.
Respond number 5.
Okay, then just say heard V. Gogoi. On request made by S.R. Barrow and the government advocate, list the matter on 31st July to enable him to file affidavit.
Well, the name of the standing council of
Registry is directed to reflect the name of Mr.
RM.
Or the standing council.
Yes, standing council of
Reflect the name
Social
of
Justice and
standing
Empowerment.
council, Social Justice and
Empowerment
Empowerment
Department.
Department in the Constitution.
Obliged.
Monday, my lord.
Yeah.
Obliged.
Hearing.
May I please, your lordship? My lord, this is a case of 2009, my lord. Yeah. And
Mr. Chowdhury, today I'm not so good. A hearing, I don't want to take.
Yes.
Unless it's.
yes,
short.
no urgency, man.
No urgency. If there's urgency, you please.
No,
You can feel free.
No, nothing else. Lordship may fix it another after 2 weeks.
But JMA Chowdhury and the council. She also had
And-
and a standing council. Which department?
Elementary math.
Elementary education department. It's up to 2 weeks.
26.
Also, since indicated that Manoj is not feeling well, next date maybe fixed notes.
Third I Chowdhury, Mr.
S. Bishwakarma.
S. Vishwakarma and the council for petitioner. Also heard Mr. B. Kaushik, then standing council,
Elementary.
elementary education department, this the matter of the one.
Oblige.
27. 27.
None appears for the petitioner. Who appears for the respondent? MSN, Bukan, and the standing council. Elementary. Appears for the respondent, appears for the elementary education department. This up to 2 weeks.
28.
My lord, this matter has already been heard several times by your lordship. What issue is involved in this case, lordship? While lordship, the petitioner was in service, lordship, he submitted an application saying that he is not interested to take the charge of headmaster. The matter is pertaining to promotion to the post of headmaster. Subsequent, at that time, he was ailing, lordship. Subsequently, after recovery from illness, he filed an application that he is ready to take the to be promoted to the post of headmaster, lordship. And subsequently, lordship, gradation list was prepared, wherein my name has been figured at serial number 1, but respondent number lordship 5 has been appointed, promoted to the post of headmaster. That is the case, lordship. Your lordship has already have gone through the various lordship.
Who appears for respondent 5?
Well, at earlier several occasions, on the last occasion he appeared.
S.K. Ghosh.
Yes, on the last occasion, lordship, he appeared, but prior to that, he did not appear. Your lordship have given one chance to for his appearance.
No, he appeared on the last occasion.
Yes, yes. So that
On 18/7.
on the last occasion he appeared, but prior to that, lordship.
No, prior to that also he appeared 36/2023.
Right. Petitioner has already retired from service on 39/2015, lordship. This matter in earlier occasion, lordship, has come as a top of the list, lordship. Now today is the bottom of the list, and petitioner retired in the year 2015. And we lordship, I am praying for a national benefit by succeed, lordship. This is a clear-cut case, lordship. The petitioner name is figured at serial number 1. After submitting my willingness to take the charge of headmaster.
Matter may be taken in.
That is, your lordship will find at page 30.
What?
Matter may be taken any other day because respondents is also not present.
Okay.
We have.
Also heard MS and Bukan and standing council elementary education department. None appears for respondent. Is the matter after?
Well, next week, lordship, third lordship.
After 1 week. I'll say after 1 week.
Well, date may be fixed, date may be given, lordship. Otherwise, lordship, will be difficult for listing.
Is the matter again on
Part or
10th of us.
my lord,
10th.
10th. My lord. Oblige.
Lordship, may please your lordship. Lordship, in item number 27, lordship, may kindly fix a date.
You were not present.
Lordship, I just missed it. I was in some other what.
Heard MS
And Begum.
and Begum Leonard counsel for the petitioner. Also heard and Bukan and standing council elementary education department. When?
Lordship, next week.
Why next week? Next week is quite full.
Maybe Lordship after 11th.
17th.
Lordship. Much obliged, Lordship.